Good. We're ready to start. Just before we start with the evidence, could I just raise one point, Ms. Peaty, and that concerns the Telecommunications Regulatory Commission, which is one of the statutory boards which is under the Premier's umbrella and one of the boards that we'll be looking at today. Under the Act, the Telecommunications Act, there's a requirement on members to make a statutory declaration dealing with the matters set out in section 7.5. Those statutory declarations should have been disclosed in general disclosure. They should have been disclosed in the affidavit we asked for, and they should have been disclosed in response to the warning letters that we sent. In respect of them, we have been sent a copy of the statutory declaration of Vance Lewis. We have not got statutory declarations in respect of three other members, Vincent Watley, Jocelyn Moraine and Bevis Sylvester. We've been told that steps are being taken to look for the statutory declaration of Mr. Watley. We need those statutory declarations, Ms. Peaty. Could I ask for them to be produced by 2 p.m. today? If they can't be produced by 2 p.m. today, could you please let me have an explanation together with, if this is necessary, if this proves necessary, the name of the individual who I should summons to produce them, together with an email address at which the summons can be sent, and confirmation that service of a summons will be accepted at that email address. Obviously, we'd send any summons we'd copy to you. But could you do those things by 2 o'clock? We may have some questions for the Premier in respect of those statutory declarations today.
Yes, sir. I'll just speak to the team, and I don't see a reason we can't have those searches done.
Great.
At the greatest priority.
Yes, thank you very much. As soon as you've got them, let us have them, but by 2 o'clock, please.
Yes.
That's very good. Thank you. Mr. Rowett.
Good morning, Commissioner. Before we continue with the evidence of the Honourable Premier, could I just introduce the legal representatives? We have in person in the hearing room Miss Lauren Peaty, and attending remotely Sir Geoffrey Cox QC, both of whom represent the Attorney General and the elected ministers. Mr. Richard Rowe is present remotely on behalf of a number of members of the House of Assembly. Honourable Premier, thank you very much for returning to assist the Commission with further evidence. When you first gave evidence on the 18th of May 2021 to this Commission, you chose to affirm. There's no need to take that affirmation again. If you look to your left, you will see 4 bundles. They will contain some of the documents that we will need to refer to as we go through your evidence. To your right, you should also see some correspondence. And in particular, there is, and I will go into this in more detail shortly, warning letters and written responses on behalf of yourself as Premier and Minister of Finance, and also on behalf of the Cabinet. Could I, as I do everyone, remind you please to remember to keep your voice up. The microphone that you see in front of you will not amplify, and if anything, I'd suggest you pull it closer to you as you go through the day. The reason I ask that is that it's important that our remote stenographer be able to hear you and take an accurate record of your evidence.
Commissioner, I just want to say thank you, and before we begin, it's my religious belief.
Premier.
I would say it's my religious belief before we begin, Commissioner, with your kind permission, and it's known fact wherever I go. I believe in my brief prayers. I say, Holy Spirit, take full control of this environment. Let your will for the people happen. And let, like when you fed the multitude, that you feed this country and feed the commission with the truth, so that your will for the Virgin Islands will come true and your will for me will come true, and each of us as persons. So bless today in Jesus' name, amen.
Thank you, Premier. Thank you, Mr. Howard.
Thank you. Could we start with some background, please, Premier?
Yes, sir.
Could you just remind us of the date of the 2019 election?
February 25th, 2019.
And following the victory of your party in that election, on what date did you name the members of your cabinet?
It was around 12th March, if I'm not mistaken, in March time.
And just to be clear, by cabinet, I'm meaning those who sit in cabinet rather than the two junior ministers that you also can appoint.
Right, that would have been, the ministers would have been, I think, in March, somewhere around in March. Yeah.
Sorry to say this so soon, but I think your voice is dropping a little bit.
Oh, I didn't realize that. I think it would be in March.
Thank you. And is the process that once you name your cabinet, they then have to be formally appointed by an instrument of appointment from the governor?
That is correct.
And when was that done? Can you remember?
I don't want to misquote the dates. I know that there was a delay in getting me sworn in by the governor, because I was trying to be sworn in as premier, and there was a delay where after being told the one day that I couldn't swear in, and the second day I insisted I be sworn in, and the governor then, Augustus Jasper, told me that he couldn't find a writ from the election office. So that threw us off about a day or two before I was sworn in. And then after that, we went back and we decided among ourselves, the minister who will be the ministers in the cabinet. And that, I don't want to say the dates, but I know it was all in March for sure.
All sort of in early March.
Yes.
First couple of weeks in March.
For sure.
Yes.
I think
Thank
we're close, going into the second week closer.
And was your first cabinet meeting also in March?
The first cabinet meeting would have been around that time, yes.
Now, as you'll be aware, the topic that the Commissioner is currently looking into is that of statutory boards.
Yes, sir.
We have heard recently from two of your ministers, the Honourable Malone and the Honourable Wheatley, and also three permanent secretaries. Tasha Bertley, who is the acting permanent secretary to the Minister of Health and Social Development, Mr. Joseph Smith Abbott, who is the acting permanent secretary to the Honourable Wheatley's ministry, and then your own permanent secretary, Dr. Carolyn O'Neill Morton, who is the permanent secretary to the Premier's office. All of them, all five, agreed with this proposition, and that is that the role of a permanent secretary is to supervise a ministry, subject to a minister's direction and control. Is that a proposition with which you agree?
Right, to supervise and advise also the minister, because they would be the ones with the institutional knowledge, because, you know, boards come and go, elected officials come and go, but the public service is the one constant. So they will be the ones with the institutional knowledge to help guide, advise ministers indeed.
So, but they do so under the direction and control of the minister, do they not?
They do so in terms of the policy direction, yes, where the minister would like to go. And I would need to correct for the record, when I said boards come and go, I mean the members. Board members come and go. And ministers as individuals come and go, just in terms of being specific.
Now, we know from Dr. O'Neill Morton that under your administration, there are 11 statutory boards which fall under the Premier's office.
Yes.
Do you agree with that number?
I think that that is a correct number, yes.
You say think, are you not sure?
Well, I'm sure of what they are. I can name them, but if you count them, I would say, yes, it's 11. I deal with them every day. So I would agree with her that there is 11.
Again, Premier, you need to keep your voice a little bit up, please.
Okay, I'll try. Usually when I speak loud, people think that I'm being aggressive, but I'll try so it doesn't come across that way, but I will try. Okay, I'll try to keep it this tone.
Now, Dr. O'Neill Morton, in relation to statutory boards and those 11 boards, has made 2 affidavits
Yes.
to the Commission. Have you read those affidavits?
Yes, I did.
The Financial Secretary, Jeremiah Frett, has also made 2 affidavits in relation to the statutory boards that fall under the Ministry of Finance.
Yes.
And he confirms that there are 10
Right.
of those. Have you read Mr. Thrett's affidavits?
Yes, I did.
Now, of the 2 affidavits from Dr. O'Neill Morton and Mr. Frett concerning statutory boards, the second of those was only served very recently and after the Commission had sent warning letters out. And so what I want to do today is concentrate on the issues that arise from Dr. O'Neill Morton's first affidavit in particular. Now, you were sent a warning letter setting out potential criticisms that may be made of you as Premier. Can I stress at this point for the record that those are just potential criticisms that arise from the evidence that the Commission has obtained? And secondly, that they do
I didn't
not
get the first one, that they are potential, you said, or not?
potential.
They are potential.
I'm the one now dropping his voice.
Okay,
so
good,
let
thank
me
you.
repeat that
Yes.
again, because it's important to make
Yes.
it clear to you, Premier.
Mm.
The other thing I should mention before I do so, that what is also important for the stenographer is that the 2 of us don't speak over each other.
Okay.
So it's my turn, and I'll just go back to that.
Thank you.
The warning letter that was sent to you sets out potential criticisms, and that is important. They are just potential criticisms, but equally important is that those criticisms do not represent either a provisional or concluded view of the Commission. They are put to you because they arise from the evidence and out of fairness to you. Now, in relation to that, you have provided a warning, a written response, and we will need to look at that as we go through. But before we do so, can you confirm that you're content that that written response from you as Premier and Minister of Finance should form part of the evidence before the Commissioner?
It should form part of the evidence.
A warning letter was also sent to Cabinet. In its content, it overlaps with matters set out in the letter to you, but also set out in warning letters that were sent to the Honourable Malone and the Honourable Vincent Weekly. Now, both of them have attended, as I explained, to give evidence as to their letters. Both of them accepted that their written responses could go into the evidence, and then we'll ask questions about it. But can I ask you whether you can confirm on behalf of Cabinet that the written response supplied on behalf of Cabinet, that you are content that it forms part of the evidence before the Commissioner?
I'm content that it can form part of the evidence from Cabinet, that Cabinet produced.
Focusing first on the written response provided for you as Premier, which should be on the table in front of you if you need to look at it. But can you just explain to the Commissioner how this was prepared?
Oh, the response was prepared?
Yes, please.
Well, it was, let me make sure I'm very clear. That's okay, this one was says written for the response from the Premier or from the Cabinet?
I'm looking at the one addressed to you. So
Okay.
it's the document headed written response of the Honourable Andrew Fahie, Premier and Minister of Finance, to warning letter dated 24th of August 2021. Do you have that?
Yes, this was, if I may.
Yes.
Okay. This was done in collaboration with the Permanent Secretary and the IRU unit, where we sat and read it and give our input into what we see as the correct answers.
When you say we, who is the we? that
Well, in
gave
terms
the
of
input?
myself, and then I will discuss with the Permanent Secretary, and we would pass it through the IRU unit, which is what is therefore based on what it was set up to do.
The reason I asked the question is because the wording that has been used in this document matches in close degree wording that appears in the written responses, for example, from the Honourable Malone, the Honourable Weekly, and also Dr. O'Neill Morton, and in fact the other 2 permanent secretaries. both Dr. O'Neill Morton and the Honourable Wheatley suggested that they put responses in their own language, and then it was turned, to borrow Honourable Wheatley's words, into legalese. Is that what happened in this case?
I can't answer it how you asked. All I could say is that I had my input in it and what I put into it. When I finalized it, I gave it just for proofing. It came back, I agreed with what is in it, and it was moved forward.
Well, does that mean that the content of this is in your words?
The content of it is in my words, my thoughts, and based on how I see the answers.
Could you now look at the written response from Cabinet? Now, again, how was that prepared?
Well, it was in the same vein. The only thing that the Cabinet, there was a warning letter against the Cabinet, which would have only included the 5 ministers to respond. So it would have been a discussion among the 5 ministers because it wouldn't have been reflecting the chair. So we would have had to discuss it among ourselves and agree with the warden, which we did. And again, we passed it through the IRU, the Attorney General with the IRU unit, and it was forwarded. So all of us in Cabinet do agree what's there. At least we should, because we did agree.
The wording of that, again, mirrors, sometimes word for word, often word for word, the wording that we find in the written response from you, and indeed the wording we find in the written response from Honourable Malone and Honourable Wheatley to their individual warning letters. How did that come about?
Well, that's very simple. We are government. We're going to discuss it, and we're going to collaborate about what we think about the answers, because it is a warning letter against the entire Cabinet, and the entire Cabinet should have one voice coming forward. And the potential criticism that was set out also from the COIs was similar in nature, just deviated based on the boards. So our answers were the same because the mindset behind what we were doing with boards and the policy that we were trying to implement was known from the inception. So it wasn't difficult for us to have the same answer and similar in most respect, because it was based on our policy and not us as individuals.
Can I come back to policy in due course?
Yes.
I think it's important that we take this in a structured way. But the point is that given that you said that your response was your words, your thoughts, and those words and thoughts appear in the response from the Cabinet, does it follow that it's your words and your thoughts in the response from Cabinet as well?
My screen, it's still up because my screen went blank. I'm sorry about it. Could you repeat that, because the screen just went blank in front of me, so I was wondering for something.
Given that you've explained that your written response as Premier was your words, your thoughts, and those same words and thoughts appear in the written response from Cabinet, does it not follow that it was your words and your thoughts that prevailed in that written response?
Not at all.
So everybody uses the same words as you?
No, we use the same words together, not as me. Our policy dictates how we respond. So we were clear from the inception, with or without a COI, what we wanted to do with boards. So to answer any questions from the COI, whether it is potential criticism or otherwise, was very, I don't want to say simple, but easy for us, because we're going to be consistent. And if you ask Honorable Malone at midnight, he will give you the same answer. If you ask Honorable Wheatley at midnight, he'll give you the same answer, because it was clear what we wanted to do with boards. So it was not a matter of my words, a matter of all words together as a group, as a Cabinet.
If you go 10, I'm afraid your written response wasn't paginated, which is not helpful, but if you go 10 pages in, please. Honourable Premier.
Could you just describe where we should be, Mr. Rowett?
We should be at a section which is headed BVI Airports Authority.
These are not numbered, so let me see.
Got that, Premier. The top of the left-hand page should be headed BVI Airports Authority.
BVI Airports Authority. Numbers somehow.
Let's start together, Premier, at the beginning. Let's start on the first page.
First page.
First page should be headed, there's a box, BVI Electricity Corporation.
That's it.
If you go through to the next page and then overleaf, you'll see at the bottom response.
Right.
And that goes through to the next page. And if you go to the fourth page, you see the number 2 in the top right, left-hand corner.
Okay.
Go on to the next page and it's a response in bold. Turn over, that response continues. Go through to the next page and you should come to BVI Tourist Board.
Continues. BVI Tourist Board, it starts in July 2019.
It starts on March 27th,
Could
2009.
I just pause? Could I just pause for a moment? What I suggest, this is going to take 2 or 3 minutes. I suggest we each paginate this document because we're going to take the Premier to other parts of it.
Yes.
And it's going to take us a long time. Is that best done by one person or all of us? What's the quickest way, Mr. Rowett?
Probably the quickest way is for one person to do it, because what we'll also need to do is we should paginate the Premier's written response as well, because that will help him get through it.
Can that be done? I know it's tedious, but I think it will save a lot of time.
It will do.
During the course of the day.
We're taking a long time to get what will actually be quite a short question, I know.
Exactly. I mean, I'll stay here, but can somebody make sure that the pagination is the same and paginate our respective responses, our respective documents?
Yeah.
Perhaps if we briefly adjourn and
I think that's probably the best thing to do. And could a copy of the Cabinet's response be put at the end of my bundle of responses? Thank you very much. Premier, I'm sorry that this has happened so early, but we're just going to break for 2 or 3 minutes and then come back. But it will save quite a lot of time during the course of today.
No problem at all.
Good, thank you. Good, thank you, Premier. I know this is your document, but I think it will save time in the long run to have it numbered, and I think we'll get through it more quickly. Yes, Mr. Rowett.
Commissioner, thank you for the time. Hopefully now that the Premier now has a paginated copy of the Cabinet's written response and a paginated copy of his own response. That may help us to get through things more quickly. Before I continue, Commissioner, can I just make mention of one thing which I ought to perhaps mention at the beginning? And that is, if I should have remembered that everyone should have their mobile phones turned off and put away. Premier, could I ask you just to turn to the Cabinet's response, please? If you turn to what is now page 10.
Yes, sir.
Do you see just above the box captioned BVI Airports Authority, there is a response, which is a response to a criticism that arises in relation to the Tourist Board. And what's written is references made to the Attorney General's earlier responses. So what input did the Attorney General have in preparing the Cabinet's response?
You said the response for the Cabinet.
Yes, at the beginning, it says written response of Cabinet. You've explained that the elected ministers came together and decided what the responses should be.
Right.
And we see, for example, at page 7, that you've made references made to the Cabinet's earlier responses. Mm-hmm. But at page 10, you say references made to the Attorney General's earlier responses. And the reason for my question is, it goes to this really, why was it considered that the ex officio member of Cabinet who doesn't have the vote should be involved in preparing the response?
But why not? Because it is an ex officio member of Cabinet, but is also the post of Attorney General. So the post of Attorney General, who would have been in Cabinet, also does carry some weight for us to sit as ministers if we have questions to ask the Attorney General. That is part of the post of Attorney General.
But you didn't mention that at the beginning. So was the Attorney General also involved in the process of preparing this? The
Attorney General didn't give us the response, but we collaborated with the Attorney General to make sure that we were answering within the line of any legal parameter, because these response, once they're made public, defines us as a Cabinet. So it was an extra safety layer that we were using as a Cabinet.
References made to the Attorney General's earlier responses. So which of the earlier responses in this document are attributable to the Attorney General?
Well, in terms of, I'm trying to see if we documented it or if it was. I think it was dealing with the Attorney General's earlier response when we were talking about not so much the Attorney General now, but more so the Attorney General's response in terms of what they gave us before when we were doing the boards. That is what I was remembering that it was about.
Sorry, Premier, I didn't understand that answer. Could you just direct the Commissioner, please, to which, having said references made to the Attorney General's earlier responses at page 10, which of the earlier responses are attributable to the Attorney General?
The Attorney General in general was asking about the questions seem to have moved towards questioning the procedure. So when we were writing the response, one of the things we were cognizant of is to reference what advice was given by the Attorney General when we were doing boards, etc., when we were handling those matters. So that is a reference that we were trying to refer to. So it's probably seen in a different light, not so much saying that this Attorney General give us any response, because that wasn't so. We give the response to ourselves.
Can I just pause to make sure I've got this clear? If you look at the previous page, which is, as it were, the criticism to which you're responding, the response being references made to the Attorney General's earlier responses. The criticism is, in July 2019, a new board membership was recommended to Cabinet to come into effect on the 1st of August 2019. It appears from the evidence that, and then there's a long list of things that arguably are defects in procedure and things which good governance perhaps requires to occur. Now, the evidence to date is that none of these things happened. There was general agreement that there was no competency profile compiled, that none of the board positions were advertised, that there was no independent or transparent process by which a suitable pool of candidates was identified, etc. That was the general position. One or two caveats from some witnesses on one or two of the headings, but generally they agreed that none of these things happened. In that context, I, at the moment, can't understand what reference is made to the Attorney General's early responses means if it refers to Attorney General's advice and guidance given to you at the time, as opposed to earlier responses within this document.
No, advice I was given previously, I think we're saying the same thing, but probably there's a barrier in terms of the of how I'm putting it, but I'm talking about earlier. I can't say that none of those things didn't happen in terms of I don't know if I misunderstood you, Commissioner, but based on what was asked and what we answered, we did a general answer, or I did a general answer, and that included any advice from the Attorney General that would state that some of those things were not done according to some of what was set out. So that is in the vein of what we were answering about, not saying that the Attorney General of the day give us any answer. So rather than writing it over and over again, because it's littered all through the document that the Attorney General advice on the constitutionality of the policy was also equivocally, and in any event, the equivocation was not discriminatory or unconstitutional. Then we have in other parts of the response, the Attorney General did not advise otherwise. He advised that it would be better to give individual reasons, and the Cabinet should do so if wished to be. And if we go through the entire documents for the response in the earlier part, it was littered with responses from the Attorney General. So rather than responding in letter questions in totality of what the Attorney General was saying, it said refer to the response of the Attorney General from earlier, because it was a refrain that the Attorney General did in most of the papers.
I understand that reference to the Attorney General might be relevant in relation to the 2019 policy. Understand that, but here it's got to do with appointments made, and none of these matters of good governance were done. And I just don't understand how the Attorney General's advice in relation to that is applicable. I mean, the advice isn't set out, but how can it be applicable? These things weren't done.
Well, I can't say that they weren't done, Commissioner, with due respect. I think that when we go through them one by one, I'll show and I'll be able to give evidence to this august body what was done and how it was done based on what ministers had to deal with when they came in just a couple of weeks old.
We'll obviously take that evidence.
Right.
All I'm saying at the moment is we've had two permanent secretaries and two ministers whose evidence is different. They accepted that none of these things happened in relation to their competitions, their appointment, including your own permanent secretary agreed that these things did not happen.
But with due respect, you said none of these things were done. So we have to look at them by board, because in some of them were done probably not in the formal sense of what you may measure me by in the what is through the lens of probably the UK or other bigger countries. But some of them were done based on our cultural makeup that has been the impetus for which government has functioned on for the last 71 years since we had the Legislative Council. So it depends on which lens you look through you would say that they weren't done. And even if they were done, it depends on which lens you look through to say how they were done. That's what I mean. So it's not to contradict or even to go in any way against whether ministers or permanent secretaries. I just want to complement what they're saying in a different way.
I understand that, and no doubt we'll go through what other witnesses have called the informal process. But what has the Attorney General got to do with it?
Well, there were areas where when a cabinet paper, as a new government, and of course not being a lawyer, and we are talking about this is a time frame when we just came into office, and we were relying on the Attorney General, the Governor and Cabinet Chair, the Deputy Governor's Office, the Permanent Secretaries, and the public officers to guide ministers, because when you take office, really and truly, the only thing that you would have is the statutory and acts. The informal process over the years, which we are now working on to formalize, but given our culture of the informal process that went on in terms of selection of persons for boards, there was never something totally documented on how to go about certain procedures. So with it now, once those informal procedures are done, given the pace that ministries work at, the cabinet papers is only one area that you're working on in a given week. So those go in the exco track, and then they're sent to usually two entities through the exco track, through the public service. One is the Attorney General, and one is the Financial Secretary. Now that would be the extra litmus test to make sure that if anything is missed by the public officers and minister at the time, to ensure that that is looked over, and of course to check the acts and to see. We do not have in the Virgin Islands, and as yet, like a cabinet office, which we are aspiring to make sure that we work towards, where there's a conflict of interest unit, where there's a litmus test to see if all these things are done before it reaches to the cabinet. And this is something that we have recommended in our position paper that we are working on to have implemented, because we are a young country still building. So if you would see through my lens, we were of the clear opinion as a young government that once it reaches these layers, whatever was missed or whatever was misinterpreted or misunderstood, because we won't know it until they point it out. You may think as a minister that you read a law one way and it's interpreted another. Chair, if I may, we have passed laws in the House of Assembly with one spirit of it. And when we saw it implemented, and it got into the courthouse, is implemented in another spirit, which was not where we intended it for it. So that's what I mean, that for us as a young government, putting yourself in that time frame of 2019, saw the Attorney General's office as that last layer that would advise and secure us from doing anything that would be deemed unlawful. And to this date, what we are saying is that all the advice received never indicated unequivocally that there was something unlawful happening. And we could go through, as we will, the section of the cabinet. We rely on that heavy when we see it. If the Attorney General's office flags something that needs drilling down on, then the paper is taken back out of the exco track, and whatever areas that are stated clearly that this needs to be done are usually addressed.
So is the short answer that in respect of these appointments made in July 2019, the Attorney General did not advise that they were unlawful or that in any way deficient?
No,
that's it.
The short answer is no. If any stage the Attorney General had warned that there was no lawful way which could have revoke appointments of these boards, we would have a deal to that.
We're just on at the moment the appointments made here in July 2019, but that's you say is the intent of the response.
That's the intent of the response.
Okay. Thank you very much.
Premier, you've conflated the process that is you've described as the informal process, which is a term that other witnesses have used, with what we find at page 10 in that letter. and if you look at what is set out at page 10, and in fact, if you look at page 9, what is put is that in relation to a particular recruitment process to a board, a number of steps were not taken. For example, that there was no advertisement, there was no independent process. Now, just to orientate ourselves going forward, all three permanent secretaries were taken through the boards, and their warning letters mirror in terms of boards identifying those that were sent to you. Similarly, the informal process was canvassed with Honourable Malone and Honourable Wheatley. What there isn't is two things. Firstly, there isn't evidence, looking at page 9, as the Commissioner has pointed out to you, that any of the steps set out at page 9 were followed. And that means that, and that was agreed with by witnesses. But secondly, in the informal process, even when we come down to individual boards, witnesses could not show and have not produced evidence to the Commissioner to show how those particular recruitment exercises, even though they used the informal process, were conducted. Now, I set out that context. We will come on to the boards in due course. But if you look at page 4, please. Page 4, at number 2 at the top, is dealing with a separate recruitment exercise to a different board. Some of the points are made there again of steps that were not taken. And there follows a long response starting at the bottom of page 4 and going on over to 5 and 6. Now that response was a response which we see mirrored in other written responses from the permanent secretaries and also, but in particular from Honourable Malone and Honourable Wheatley. When you go to 3 on page 6, in relation to the recruitment of one individual, the same criticism was made, and the reference is made to Cabinet's earlier responses. So when we come, and that would appear to be a response to the fuller response that we see at 2. When we come, therefore, back to page 9, and the same points are made, the difference is references made to the Attorney General's earlier response. And so your evidence, just so that we're clear to the Commissioner, is in that answer, the Cabinet were wanting to add an extra level of detail in relation to advice given by the Attorney General to you in relation to that particular exercise. Is that right?
Well, I would say, Attorney, these questions earlier, and after we answer them, I answer them and look them over after, most of the questions were similar. So rather, you're saying that the questions that came later, we started to reference the Attorney General's response, and wanting to make sure that the deadline that was put on me as Premier, given all that I was doing, wanted to make sure that after a while, answering all these questions, going straight through, to be as clear as you can be for the Commissioner to help. And rather than rewriting the same thing for the Attorney General, we just started to write the Attorney General's response from earlier to reference the same thing. So that's how I see it.
The difficulty, Premier, which you have not been able to assist the Commissioner with, is that when we get through the first 10 pages, it is just impossible to identify a response which is attributable to the Attorney General. If you had said at the beginning, which you've specifically not said, is sorry, that was a typo, and it should say references made to the Cabinet's earlier responses, that would have made sense. But what you cannot do in this written response is identify the specific earlier response of the Attorney General, can you?
I don't think that we seeing each other through the same eyes from probably a cultural language point of view. When I say that reference is made to the Attorney General, I'm meaning that the advice that they would give on each one of those papers for each one of the boards. So I don't know if it's being looked at, Commissioner, in a different light, but that is how I look at it when I was responding to the question. So I did it in a light to assist. I thought that I was assisting, so I just needed to point that out.
If that's what you meant by that response, and a similar response is given later on to in respect to the Social Security Board, if that's what you meant by that response, where are the earlier responses? One would have expected in a document like this, for those early responses, the documents you're relying upon to be referred to.
If I may?
Yes.
Is it what I'm referring to is in the earlier response? It was highlighted in earlier responses, as I read before, that the Attorney General did not point out any legal issues. For example, on page 6, it says, advised by the Attorney General, the Deputy Governor, that all appointments should be advertised. The newly elected appointment governor was not then in March and April advised by the Attorney General, the Governor, or the Deputy Governor that all appointments should be advertised. That's one reference to the Attorney General. Then there are some other references as littered through the entire document, stating clearly the Attorney General did not advise otherwise. He advised that it would be better to give individual reasons, and the Cabinet should do so if it wishes to be consistent with the public administration. And then when we look at other areas, the Attorney General, I quoted some of the things that the Attorney General stated or quoted or paraphrased. Some of the areas the Attorney General certainly did not advise the Cabinet that there was no respectable argument that this policy was a lawful basis.
I'm sorry to interrupt, but can I just get this absolutely clear? We're talking in the response that we're focusing on page 10. Right. It's the response to a potential criticism that various steps in relation to the appointments, various steps were not taken, and that's a potential criticism. Right. Where that criticism is dealt with on page 6, which you referred to, it's not, there's no response by the Attorney General. That simply says that the Cabinet was not advised by the Attorney General that the appointment should be advertised and candidates interviewed, etc. No, at the moment I'm sort of lost in your answer, but it may simply be that we'll need to press on. How I read this, Premier, when I first read it was that the reference there on page 10 to the Attorney General's early responses, and I think there's a similar response later in respect of the Social Security Board on page 22, references made to the Attorney General's early responses. That was simply a typographical error for the early responses in this document. Mm-hmm. That's how I understood it. Okay. But as you say, these are in your words, and you understood it in a different way.
I understood in a different way, Commissioner. With due respect, I understood that once I was answering, most of the questions, save 1 or 2 words or 1 or 2 deviation, were the same for nearly all the boards in yes. My reading of it.
But the answer on this board is different from the answers your answers in respect to the other boards.
Right. But at the same time, the gist of the basis of my response, saying that refer to the Attorney General's response earlier, means that the advice given even for this board was similar to the others, which was that there was nothing unlawful, or it was nothing unequivocally stating that this way cannot be done. So that is in the vein in which where I was responding.
Yes, no, thank you very much. I understand that. Thank you, Mr. Rowan.
If we can move on, Commissioner. Honourable Premier, you've referred to the informal process, which is a term that other witnesses, as I explained, have used, and they have given the Commissioner quite a lot of evidence about how their understanding of that process. So what I want to do is just lay it out and summarise it for you. And the sources that we have for that are the written responses of the 3 permanent secretaries and also the 2 ministers. And when one looks at the written responses, there are strikingly similar descriptions of the informal process by which it is said appointments to boards are currently made and have been made in the past. And that wording finds its echo in the Cabinet's response and in your own response. The witnesses, as I said, also confirmed the process in their oral evidence, and it comes to this. Firstly, there is an informal process by which individuals are recommended to a minister for membership of a statutory board. Those recommendations can come from a desk officer or from a permanent secretary or from the minister himself or herself. The minister may take informal soundings. So, for example, Honourable Wheatley gave the example of when he needed to find representatives of employers and representatives of employees. He went out into the street to people he knew and asked them who would make a good representative. Other ministers may make recommendations. But what was agreed was that this was essentially an internal process. Certainly it doesn't involve any element of advertising, etc. Once the recommendations come in, the minister decides who will be nominated to the board. The next step is then that pool of nominees are approached and they are asked if they are willing to serve. And if so, they are then asked to provide a CV or a resume to the relevant ministry. As to a conflict check, it appears to go no further than asking the candidate if they considered that there might be a conflict if they were appointed to the board. Once the CVs come in, or the next part of the process is that a cabinet paper is then prepared, and that will ultimately be signed off for the minister who is going to take that paper to cabinet. Now, during that process, CVs and resumes received might be considered further. And Dr. O'Neill Morton pointed out that at least in your office, convictions and spent convictions are taken into account. And she said, when she was asked about this and how that process worked, when she gave oral evidence last week to the Commissioner, she said that most people in what is a small community will know if someone has a spent conviction or indeed a conviction. It's a matter of common knowledge, and that's what's relied upon. The minister has the final say as to which names go into the paper. That was agreed by everyone. And the paper, as I understand it, goes onto Exco Track. There is a date on the front, which will be the date on which it goes into Exco Track. The 2 other ministries, absent any need for cross-ministry consultation, the 2 other ministries who will be involved routinely are firstly the Ministry of Finance to look at financial implications, and secondly, the Attorney General's Chambers to look at legal implications. The paper is then taken to Cabinet. That paper may be amended during the course of Cabinet discussions. Cabinet may delete a letter, a line from the paper. But what we see at the end of the paper is the name of the minister who has taken it to Cabinet. So in your case, it will be your name and your title and the date. And sometimes that date mirrors the date of the Cabinet meeting. But what it tells us is that's the date on which that, if you like, the minister, having agreed to take a set of names to cabinet, also signs off the paper. Now that's, I hope, a fair summary of the evidence. Do you agree broadly that that's the informal process?
That broadly the informal and the formal process put together, because the exco track is a clear policy of how things would move after the paper is done.
Yes, that's a procedural point, but in terms of the steps that are taken, that is what the evidence shows, and you don't dispute that evidence as to the process by which people end up, their names end up in a cabinet paper. That's right, isn't it?
Yeah, they would be notified before.
Well, as we go through, I can show you some examples of people being notified before, if we need to look at that. Now, Dr. O'Neill Morton also explained to the Commissioner that the Honourable Dr. Natalia Wheatley, when acting Premier, made a policy decision on the 1st of June 2021 to advertise vacancies in relation to boards that fall under the umbrella of the Premier's office. And exhibited to her second affidavit are examples of vacancies being advertised. Dr. O'Neill made two further points. Firstly, that it's her hope that, and she described your office in effect as the lead ministry, but it's her hope that by taking or beginning to take these steps, that would encourage other departments to adopt a similar, more formal process. The second point that Dr. O'Neill made was that it hasn't moved as quickly as she would have hoped. There is a procedural manual still in preparation. And at the time she gave evidence, which was last Thursday, that manual has not been provided to the Commissioner. It was subsequently. And it says at the top, this manual is a working draft that is still being edited, proofread, and tested, and should not in any way be considered or referred to as a final document. So you will agree that before you can take that formal process much further, that manual needs to be in a more finalized form. Would you agree with that?
Yes, Attorney, but if I may, we have reached the end of us recognizing something that I need to be allowed to go to the beginning of, because I listened to the attorney being able to bring his point across very eloquently. The culture of any place has to be also factored in when you're doing the laws. I'm not a lawyer, but I know this from being in the House. Meaning that if the United Kingdom is considering a law to be passed or a new policy, they will not base it on the culture in the Virgin Islands or in Afghanistan or anywhere else. It'll have to be based on the United Kingdom. And if the BVI is doing a new policy in law, they'll have to base it on what the culture is.
Well, it's the culture. I'm sorry to interrupt. The culture and the circumstances.
And the circumstances.
The circumstances are different.
And also bearing in mind to recognize what's happening internationally. That is key. I said that to say that the impetus that we must have inside of the Commission of Inquiry to be considered is the culture of the Virgin Islands, of it, how it was being dealt with over the years, and how did it get to the informal state, because that's where it started. The BVI started with the Legislative Council 71 years ago. There was only about 5,000-6,000 people. Everyone knew each other. And over time, persons basically know each other in the BVI. Commissioner, if you stay here long enough, they will know where you have lunch. So they'll know where you go to church. You'll know each other. So that's the culture of it. So with it now, the informal process was still one yet of which it wasn't that you didn't know these persons at all. Now that has been practiced over the 71 years, but we recognized in the Premier's office as long before the COI had started, that this now is evolving because our population has moved from 5, 6, 7,000, from 12, 14,000 now up to 35,000 and counting. Some say 30, some say 35. So we recognize now that although what got us here has merit in our eyes and needed some adjustment in our eyes also, we have moved towards that stage and prompted ourselves to move towards what has just been described, and with advertising now for boards. So, Commissioner, you'll have to excuse me that when I receive a question from the Commission, why wasn't the post advertised? That's a legitimate question coming from your lens out of the UK or a bigger country. For us, most of that was not part of even most of the acts. And I guess we'll get into it later on, because I do agree that adverts are good. But we also have to look and see if that is the best way to get the best candidates, with some other ways that we can have working in tandem. So I want to state that with using the word of, in terms of having it advertised as the key for being the flag bearer to allow good governance or to allow the best candidate, that would not be the only way, given the dynamics of this culture, and I'll get into that more as we give evidence.
It might not be the only way, because there are a number of ways to have good governance. I certainly accept that. But the evidence to date, and your evidence, is that the procedures, the informal procedure, as it's been called, was an internal procedure. And so nominations were identified internally by the minister, by the permanent secretary, by the desk officer, anybody else who happened to feed a potential candidate in.
Right.
But it was an entirely internal procedure. And this isn't entirely to do with numbers, although I see that that's a compounding factor. But even if you knew everybody in the territory, there may be somebody in the territory who would be willing and able to serve on a particular board that has the right qualifications and experience, but he is not identified by this internal mechanism. He can only be identified by some mechanism which has an external element. And we'll come on to the new process, the more formal process, in a while. But that must be right, mustn't it, as a proposition? Even if you knew everybody, which, as you say, you may not now because there are so many people here, but to maximize the possibility of getting the best people on boards, the procedure has to have some external element.
Yeah, I would say yes, but in tandem. You're correct, Commissioner, but in tandem. And if I may, for example, we came in with a mandate of change, and we're going into the boards. And if I'd be allowed to give my evidence to help with your report.
We're coming on to the onto the 2019 policy in any event.
Okay.
What I'm particularly interested now in is the informal process.
Right. Well, the informal process is one in which all that has been described is one that you usually do. But at the same time, too, when you give it to the Attorney General, or even when you reach the cabinet, if there are any issues that come up legally, then you would have them addressed. For example, it was stating that if someone has a conviction, is one of the areas that I heard the attorney mention. But in all laws, there's also a section that if the person solves, I think is not beyond 6 months, and their records is expunged, then it cannot be referred to, and it's like it didn't happen in terms of layman terms. So you cannot legally hold them to it. You know, cultural, in a Christian religion, that's called God's grace and mercy. But in legal, it exists. So in any case where that came into question, the Attorney General was referred to, and the Attorney General was asked to give us your legal interpretation of any person who that may happen to or be can fit on a board. And he came back and always would say, based on whatever circumstances that represented, the answer is yes, they can go on the board because there's not an issue based on how the law is phrased and based on records being expunged. I've never had a case where he said otherwise, because we'll try to get at that before it even reaches the cabinet by trying to check with certain laws, etc. Now, also remember that when it goes to the Attorney General, the comments on the paper is one thing, but there's discussions that happen on the phone between the Attorney General's office and the respective ministry. So there'll be what we'll call, again, an informal process that's happening. Could you tell me why this is here, or whatever the case may be? So there's some checks and balances, even in the informal part of speaking with the Attorney General office and the sponsoring ministry of the paper for wherever the board is coming from, or whatever paper is coming from, period, whether it's a board or otherwise. So it is hope that in the past that those areas would be ironed out. However, we do recognize that the country is evolving. So in evolving now, we have moved towards, without being prompted by anyone, we have moved not just to have a chairman advertise, we're moving towards having all the members advertise. But I want to also say that in moving towards that, there are some areas that came up as challenges, because it calls for some amendments to some of the legislation to allow some of what we need to do to get done. And also, we are discussing if we can bring a whole statutory board amendments act of how we want to do overall statutory boards. So that also is in discussion, because that might be a mop-up exercise for all of them one time to fall under that. These are the measures that will be in place. So we're evolving as a territory over the 71 years history. And now we're moving to another paradigm shift where the UK would have been already, because it's much older than us. Now that we recognize that this is one of the areas we want to go. But can I say, Commissioner, that advertising different posts for board membership is a noble course of action, but I would say also that it's not a silver bullet, because you would advertise doesn't necessarily mean that you're automatically going to get the best candidate. I will give you this. We have had posts in the public service that I've seen over and over advertised, and only one person applied. And sometimes you would say, well, all right, you don't think that one person is the strongest, but you went through the advertisement and one person applied. Then we would ask for it to be reapplied, re-advertised, sorry. It will be re-advertised. I have saw where one person still come back and applied. So it comes down now where the informal process would be that let me see, or anyone who is involved, if they can nudge someone and say, well, in the interest of the public, and which is the country, would you consider applying? Would you consider serving in the interest of the public? So that's just one example of where advertising sometimes doesn't reach the best candidate. Not saying that the methodology is incorrect and not needed, but it cannot be done in isolation to prompting and other means of processes to help us to see if we can get some of the best candidates.
But to go back to my question, an entirely internal process reduces the chances of getting the best candidates. That's the proposition. My understanding of your answer, but correct me if I'm wrong, is that you accept that. You say that just taking one element, advertising, that may not be sufficient. People may need a prod. They need a prod in other jurisdictions too. Other jurisdictions only have one or indeed no responses to an advert. But at least advertisement or other ways in which the process is made external and open and transparent. In terms of governance, that's good. And in terms of the chances of obtaining better candidates, they are increased. You may not get the best candidate. You may get the best candidate by walking out into the street and putting your hand on somebody's shoulder. But by having an external process, do you accept this is the proposition Mr. Rawat put, that the chances of obtaining better candidates increases.
Oh, by far, because it adds another layer to the informal one.
Yes, because it adds people into the potential pool.
But I can't. But what I would not be able to accept is that the informal process did not produce some good and proper persons or fit persons or good candidates.
No, with respect, so far as I'm concerned, and so far as the other evidence is concerned, that's an open door. We are not saying there are no criticisms that any particular candidate in any particular board member on any statutory board is not a fit and proper person to do that job, because we don't know. We might know if the governance was better, but we don't know. That's not a criticism. The criticism is about the process and about increasing the pool of candidates for particular posts. That's all.
I agree, Commissioner, and I really like how you put it. But may I graciously add?
Yes.
The putting together of the board, when you say that the process is an issue, first of all, in the areas where there's no statute and there's just regular policies, or then the question is, if it was deemed as one of the legal things to do to advertise. So to hold governments over the 71-year history of not advertising, because it was something that was never done across the board. So it cannot be a systematic failure in the current government. It has to be not a failure, but it has to be something that was just an understanding, and we need to involve, which we are doing now. But in that process of selecting the person, there's a lot that goes into it, and a lot of informal discussions that go into it.
I'm sorry again to interrupt, but again, you may be making a proposition with which I agree. Okay. The evidence to date is that a good deal of effort went into identifying people to take on these board posts, and the criticism is not phrased in terms that nobody made any effort to do anything. The criticism is that effort was not made in the best way to obtain better or the best candidates, and because it was an internal process. And that is a proposition that seems to me, limited though it may be, to be a good one.
Could I add a little word to
yes.
the criticism? To further increase the ability to get yes. Potential
yes.
better. I would add those words in it, because
no.
I think we together was just a few words that were missing.
No, I think we are. That it's to increase the chance of getting better candidates.
Yeah, further increase. That word further would be good.
If you would permit me just to point out that throughout the warning letters, generally there is a paragraph 9 in the enumeration of defects in good governance, which reads, "It follows that no effort was made to identify and select the most suitable and qualified candidates." That is not consistent, of course, with the analysis you've just provided. An effort was made, it may not have been the best effort. And I think the Premier has that in mind.
I insist on that.
No, I'm sorry, Mr. Robert. Let me just deal with this point. Sir Geoffrey, firstly, welcome back. Thank you for your intervention. Because I think I fully understand the Premier's position on this. The reference to paragraph 9, for example, on page 9 of the Cabinet document that we're looking at, it reads, "It follows that no effort was made to identify and select the most suitable and qualified candidates for membership of, in this case, the Tourist Board." And the important thing is the most suitable. Efforts were not made to find the most suitable. Efforts were made to find fit and proper people. And as I say, I accept that in some cases, certainly the evidence is considerable internal efforts were made But internal efforts alone, as the Premier accepts because it's right, internal efforts alone do not go to finding the most suitable and qualified candidates.
Well, forgive me. It's not for me now to debate. It's your commission of inquiry. But I think that the language could be interpreted as meaning that no sincere effort was made. In other words, as you said, the public officers made a great effort to try to find suitable people. If what you're saying is they couldn't find the most suitable unless they advertised, well, of course, the Premier has just accepted that. But with respect, I think it's a matter of linguistics here. It does say no effort was made. There was an effort made. There was a lot of effort made. Now, they may have needed to improve their systems, and they would have thereby found better people, perhaps, or not. That's, I think, all that I wanted to. Forgive me, but I do think this is the way it's been interpreted up to now, is that somehow, and I'm grateful for what you've just said, because I think it will help with the departments affected, that in some way the inquiry was suggesting that really they weren't going to any effort at all, that it was, but as you've said, a lot of effort was put in. It should have been improved, no doubt, with the systems that the Commission is suggesting.
Well, Sir Geoff, as I said, that's a submission, and at the moment we're taking evidence. The focus, my focus in that paragraph is on the most suitable and qualified candidates, and that was merely to indicate that without some external element, the chances of finding the most suitable and qualified candidates are restricted. The Premier and I think all of the witnesses have agreed.
I shouldn't have, forgive me for extending this. I mean, as you say, it's a discussion for later. I see what you mean. I was just anxious that the Premier, I know what his concern will be, having discussed matters with him, and I wanted just to put it before you, that it wasn't that no sincere efforts were made to find good people.
As has been clear from the previous evidence, efforts were made to find fit and proper board members. I'm sorry, Mr. Wright, for firstly interrupting and then stopping you on the question. But
can I just make 3 points? I mean, I think as you've indicated, Commissioner, it's very important to not to stray into submission at this stage. Secondly, to reassure Sir Geoffrey, in his absence, this was canvassed with the permanent secretaries and with the 2 ministers who've given evidence, and the point was clarified with them that the thrust of the criticism was about a process that does not recruit the most suitable and qualified candidates. But also, I mean, we may see this if we get into the detail on individual boards with the Premier. The informal process with limited example does generate evidence. The difficulty has been, as the permanent secretaries in particular acknowledged when we were looking at individual recruitment exercises, they could not find any evidence as to how those recruitment exercises had been undertaken. And so they always fell back to the general. And the general is a form of words that the Premier uses in his response, the Cabinet uses in their response, and indeed the Honourable Ministers and the Permanent Secretaries do, and which I have just outlined. But perhaps if I could move on to the next topic. And
what is the next topic?
Well, the next topic is I was going to deal with the new policy with the Premier.
Could I just raise one question? And if you're going to come to this later, Mr. Rawat, we can deal with it then. Because it was something Mr. Rawat said in setting out how the informal process had been adopted and how it had been changed. And he said that, I think he said on the 1st of June, there was a policy decision made by the Deputy Premier that vacancies for boards within the Premier's office would be advertised. And I think there were five boards, possibly more posts, but 5 boards that were then advertised. And I think what the evidence was from Dr. O'Neill Morton was that that was the day that he made an announcement. No doubt it being a policy decision, it would have been a policy decision, firstly, that you were involved in, Premier, and secondly, no doubt a policy decision of Cabinet. But she said that the policy decision was made on or about the 1st of June. Is that correct? We'll come on to the detail of the new regime, but is that correct in terms of timing?
Commissioner, I would say roughly it should be, because I don't like to quote dates and I'm not accurate. But I keep hearing this section of where the Deputy Premier introduced. But there was a Cabinet paper that was an information paper that was taken to Cabinet that was stated that this is where we would like to go and start with what you would call a pilot of it, so that we can then make the changes. So that was, we couldn't do it as a decision paper as yet, because the decision paper will call for us to have to review all the statutes in many other areas. So we wanted to start as a pilot project inside the Premier's office. So that I just needed to add that in there. That was produced before.
But and that was shortly before the 1st of June. I think it was from a media article.
We can look at it if it's in bundle 4 and it's a government press release.
Unless you're going to deal with this later, Mr. Rowett.
I wasn't intended to. But if we turn up first of all, part 4, bundle 4, Premier, it's part 4 bundle, page 3313.
Yes.
3313.
Yes.
That's yes, right at the beginning. Yes, thank you.
And 4.11.
Okay, it does say make a policy decision.
And the press release you had in mind, Commissioner, is at 3551.
Let me just read this out for the record.
Yes.
It says, and this is Dr. O'Neill Morton's affidavit.
Yes, her third affidavit.
Third affidavit, paragraph 4.11. As stated in paragraph 4.1, the acting Premier, Dr. the Honourable Natalio D. Wheatley, via a press release dated the 1st of June 2021, made a policy decision to advertise vacancies that become available on the statutory boards that fall under his portfolio. Yes. And the press release is
3551. And you can see, Commissioner, at 3552, the vacancies that were advertised were for boards that come under the Premier's office, specifically the BVI Airports Authority, the BVI Ports Authority, Prospect Reef Resort, the Gambling, Gaming and Betting Control Commission, and the Virgin Islands Trade Commission.
That's it. And again, Mr. Rowett, just to remind the Premier, I think when the Premier last gave evidence, or on one occasion the Premier gave evidence, he referred to this. Is that correct?
I'll need to double check. It will be
in May.
On the 18th
Premier,
of May,
you said
day 6.
This was on its way. So it's sort of the second half of May anyway. A policy decision was made and then announced by the Deputy Premier on the 1st of June.
Right.
Yes.
Well, the Deputy Premier would have announced it because I've been out of the country as acting Premier,
yes,
of course.
Yes.
But it came from a Cabinet paper, information paper, might I add, that this is what we want to do as a pilot project. But to be fair to the public officers, you would agree that between me and now, we we were dealing with a spike that went up to 1,600 cases. So a lot of persons were out of office, and that created a problem.
We made this very clear to Dr. O'Neill Morton. Nobody could criticise any delay from then to now. I know that I think the first interview or something's just happening,
Right.
but we understand that that's for very good reason.
Okay.
And Dr. O'Neill Morton has explained the context to the Commissioner when we were dealing with this.
Yeah.
Okay, beautiful.
Is that all on that? Do you want to move on to another?
It is. I do want to move on to another topic.
Is now a good time?
I was going to suggest that we did.
Premier, we have a break because the stenographer, robust as he is, needs a break after about an hour. He's there doing his work. Just a 5-minute break, and then we'll come back. And could I just remind you? I needn't remind you because Sir Geoffrey Cox and the others who are with you fully understand this, but obviously don't discuss your evidence during these breaks with any of the legal advisors. Do you understand that?
It was fair enough.
Thank you very much.
Yeah.
Good. Anything else?
That's it. Thank you.
5 minutes. Thank you. We're ready to resume. Just before we move on to the next topic, Premier, you referred to an information paper, I think you called it, that went to Cabinet.
Yes, sir.
I think shortly before the 1st of June, when the announcement was made of the change of policy in relation to appointments process to statutory boards. I'm not sure that I've seen that. Could we identify a copy of that? That's something perhaps Miss Petey can do, if we can identify that and send it through to us.
This was an information paper.
Yeah, an information paper, and that will be helpful in substance and also give us a date when it was taken to Cabinet. Thank you, Mr. Rowett.
Thank you, Premier. Could you pick up part 3 of the bundles, please?
Page
2928, please.
Thank you.
2928. You should have in front of you, Premier, a paper from your office with the date 19th of March 2019 at the top. It's memo number 103 of 2019,
Great.
and it's headed Revocation of Membership of Statutory Boards under the Premier's office.
Great.
It begins with a explanation about what statutory boards do in the Virgin Islands, and that paragraph, which is paragraph 1. It explains that they fulfill the requirement from operational independence from the government. However, funding arrangements are dependent on the annual appropriations processes in most instances for those statutory bodies who receive their annual budget allocation by way of a subvention from government. Paragraph 2 then lists a number of statutory boards under your portfolio. And if we go then to 4, there is some misnumbering of paragraphs, but it's paragraph 4. If I just read that out, it says, with each new government administration, it is common practice that some or all current board membership is dissolved, new members appointed to the respective boards. The manifesto of the new government administration calls for innovative, forward and progressive ideas, initiatives and action from each government ministry, department and agency during this recovery period. For those initiatives that must be implemented through a statutory body, the same principles for innovative, forward and progressive initiatives and action will be required. Paragraph 5 reads as follows. The manifesto of the new government administration places heavy emphasis on youth involvement in every aspect of the development of the territory. As such, the intention is also to appoint a youth representative on each statutory board and committee. In addition, recommendations will be forthcoming for a new policy to amend the membership terms of each board to not extend beyond the term of the sitting administration that appointed the board. As such, this is paragraph 6, which reads, as such, Cabinet approval is being sought to revoke the membership of the current statutory boards under the Premier's office portfolio, to allow for the right mix of new, innovative and progressive-minded members to be appointed that would include representation of youth on each board. And if we go, it's under financial implications, but I think it's in fact referring to comments of the Attorney General. But at paragraph 9, what's written is, I've noted the comments of the Attorney General when he stated, I have not had the opportunity to review the removal provisions of all the boards, statutory, corporation or otherwise. To this end, it is critically important that Cabinet satisfies itself that even in the cases of the BVI Ports Authority and BVI Electricity Boards, wherein there is express provision for the removal of statutory members, and as cautioned by the Attorney General, the discretionary powers of Cabinet must be exercised reasonably. In light of the above, this is 10, in light of the above, before Cabinet takes the decision to remove any board director of a statutory board, Cabinet must satisfy itself that it not only has the power to do so as per the respective statutes establishing the board, but that in removing the directors en masse, that this will not be easily construed by any arbiter as acting / behaving unreasonably. To act otherwise in these circumstances may expose government to claims of unreasonable dismissals, which in turn could result in huge financial liabilities being attached to government. And then under legal implications at 11, it reads, may I note further that there is no provision for revoking the appointment of members of the Tourist Board, but that is cured by section 20 of the Interpretation Act, which authorises an appointing authority to remove an appointee at its discretion. This, of course, entails compliance with the rule of law requirement that I previously made reference to. Pause there, because if we go to page 2737 in the same bundle.
Just before we do, Mr. Wright, it seems to me that, to be fair to the Premier, paragraph 7 as well, paragraph 7, which is headed purpose, the purpose of this was to dissolve current board membership and appoint new board members.
Thank you.
Yes.
Premier, if we turn to page 2737, please. You will see we're now at the Cabinet meeting number 2 of 2019. And these are the minutes, the 27th of March 2019, a meeting of Cabinet which was chaired by the Governor. If you go to 2739, please, Premier, you'll see that this paper was then put before Cabinet by yourself on that date. And if I just read out some parts of the deliberations, and which begin at paragraph 3, the Premier presented this paper. The Chairman stated that specific reasons or a reasonable justification should be given to remove persons as members of a board. He asked if there was sufficient reason in this regard. Whilst the paper was in relation to all statutory boards under your portfolio, of particular interest was the Ports Authority and the Tourist Board. But the Attorney General then continues at 5. The Attorney General confirmed that the BVI Tourist Board Ordinance does not reference removal of members from the board. Therefore, in this instance, removal of members can be carried out on the basis of discretion. The Chairman reiterated that there is no specific removal power in the ordinance, but that he understands from the Attorney General that such a clause is included in the Interpretation Act. The AG said in cases where any powers are conferred by the legislature, one should provide reasons for removal of persons, and suggested that it is better to provide reasons. The AG advised that if this administration wants to be a government consistent with public administration, then reasons must be given for removal of members of boards. Members asked if there was any precedent of unreasonable exercise. Apparently, we're now at point 9. The Minister for Health and Social Development commented that given its national mandate and that tourism is an economic pillar, it should be deemed reasonable that the tourism minister be comfortable with the membership of the BVI Tourist Board to move the sector forward, and therefore should be mindful to appoint a board that reflects his administration's mandate. 10 reads as follows. The Chairman stated that there should be an avoidance of risk of targeting people. He voiced his concern about the caption paper and that he was not against its intention, but that he wanted to ensure that there was a demonstration of good governance procedure. The Chairman reiterated that justifiable reasons should be given to remove members from a board. At 11, we have this. The Minister for Natural Resources, Labour and Immigration mentioned that the decision was not for the removal of one person, but the entire board membership. 12 continues. The Minister for Health and Social Development asked the Attorney General if board members had a legal recourse for being removed. The Attorney General responded that anyone can go to court, whether they have legal recourse or not. The Chairman asked if there were any operational liabilities or risks to revoking the appointments of the members of the BVI Tourist Board or BVI Ports Authority. The Premier responded that there were no risks to either entity if they operated without a board at this time. At 15, it reads, the Premier stated that his decision to revoke the membership of the board is on the basis that a new government has assumed office with a new mandate. And as a result, he has decided to reassess the membership of all boards in a manner that will allow the mandate given by the people to be expedited in a transparent and accountable manner. Furthermore, the Premier stated that he would be recommending a policy that the membership on boards would extend for the duration of the administration's term in office. The next section is headed Action By, and the actions that followed were: the Premier would instruct his office to prepare a cabinet paper that the periods of appointment of members serving on boards would be commensurate with the administration's term in office in consultation with the Attorney General's chambers. In support, the Minister for Education, Culture, Agriculture, Fisheries, Sports and Youth Affairs agrees that boards should not exceed the tenure of an administration because it can prove to be challenging. The Minister said that despite the possibility of exposing the government to certain levels of risks, when he weighs the potential for boards to interfere with the government's mandate, as a member of cabinet, he was willing to be exposed to that risk. He stated that commitment to the current government's mandate from the people must be paramount because incorrect actions of the past and or an association with a former party or administration could have a real impact on how matters progressed. At 20, we have this. The Minister for Communications and Works voiced his agreement and support of the sentiments expressed with respect to the revocation of the membership of the captioned board. Voicing his concerns, the chairman said that the cabinet has wide discretionary powers, which should be used in accordance with principles of administration and not without justifiable reasons. This, he said, risks undermining the cabinet's commitment to good administration and good governance. The Premier thanked the chairman for noting his concern on the matter, but pointed out that the chairman's definition of justifiable reasons differed from theirs. And the decision sought and was granted was firstly that Cabinet approved the revocation of the appointments of all members except the ex officio members of two boards, the British Virgin Islands Tourist Board and the British Virgin Islands Ports Authority, and then decided on the issuance of an expedited extract. Now, this is...
I'm sorry, Mr. Rowett. Just to put this into context, Premier, although I'm sure you have fully grasped this, the policy expressed appears to be a general policy, but the two boards involved, the Tourist Board and the Port Authority, were both statutory boards where there were no express provisions in the mother statute for revocation of appointments, and hence the interpretation that they were both in the same position. Sorry, Mr. Rowett. Yes.
The passages I've read out to you, Premier, are a convenient starting point and a basis on which to ask you about the policy of your administration in relation to statutory boards. And the reason I say that is because it was something I also canvassed with Honourable Malone and Honourable Weekly. Taking what they said, and using this as a foundation. There are other documents that we may look at as we get into more specific boards which echo this policy.
Mr. Rowett, I can't recall any earlier documents than this. I can't recall any information paper or any paper to Cabinet before this.
No, I don't believe we have seen anything before this.
The answer to this may be obvious, but I'd still like to hear it. This paper is dated as a draft, not when you approved it, but as a draft on the 19th of March. And you said your administration came in at the end of February, appointed your ministers in the first couple of weeks of March. So this was very early on in the administration. Was there any other policy paper before this that we should be looking for?
No, not a policy paper, but when I get a chance to respond, I'll explain a few things.
Thank you very much.
But if I summarise the policy and I draw on the assistance that was given by Honourable Malone and Honourable Weekly to the Commissioner, but it comes to this, it's firstly, that boards should have a membership that show a commitment to an administration's programme. Secondly, that boards should have, in terms of their representation, should have youth representation. And thirdly, that the tenure of a board should match the tenure of an administration. And I've said an administration in all of those rather than your administration, because I think, in fairness to you, the effect of that policy would, unless a successor administration were to change it, would persist even if you did not form the government. Now, you've first step is, as a summary, in terms of the principal elements of the policy, do you agree with those?
In terms of the principal element, if I agree in terms of what section?
Of those 3 points, those 3 headlines that I've given you. Firstly, that a commitment to an administration's programme. Secondly, youth inclusion. And thirdly, the point about tenure.
Right, and we are going to reconstitute them to bring further energy would be one of the areas of them. I would state, if I may, I don't know if I can answer now.
Yes, before you do, Premier, your voice dropped and you
Oh no,
said
I was saying that along with some other areas that we are looking at. Yeah. But there's an important ingredient that needs to be added in. But when I get to respond, I'll put it in.
It's just we didn't catch. You said to reconstitute them, and then you said something.
Yeah,
referred to energy, and I just
energy.
If you could just give that answer again, please, for the transcript.
New energy in it. We wanted to bring on, and still want to bring on, a youth representative, Sister Island representative. We want to make sure that we get as much cross section as possible. But the challenge with that as we went on, because you can appreciate that you're talking about just a few weeks into office. A young government with the desire and the mandate came in with a mandate of change, came in with a mandate that we wanted to push ahead all in the public's interest. I want to state that in terms of with the Attorney General, did not advise with any clarity that anything unlawful was being done, because that was one of the main area that we keep trying to drill down in the conversations that probably wasn't fully captured in this, but was part of Cabinet's full discussion. And as a new government and not being lawyers, which I wouldn't pretend to be, we were relying on the Attorney General, the governor as his cabinet chair, the deputy governor's office, the permanent secretary, and public officers to guide us. Because again, Commissioner, you would know this from your long successful career that one's interpretation of reading the law through a layman is different from one who's a lawyer, and then even 2 lawyers may interpret it differently. So we depended heavy on the Attorney General because we are not lawyers, and all cabinet papers, as we rightfully went through already, go to the Attorney General for legal implications. But then the AG would have been presumed to have read the relevant cabinet papers and put his comments into the exco track with his legal views, which he has done. And if at any stage from these, what you have presented to me, that the Attorney General had warned that there was absolutely no lawful way by which our government could revoke the appointments of these board members on the basis of the new government's policy of what I would call reinvigoration. That was what I was looking for, reinvigoration, and the shaking up the boards and aligning them with the values of the new government. And when I say values, I mean like the young people, Sister Islands, what I've mentioned before, greater cohesiveness and greater energy. We would have asked him to advise us on how to proceed but you did to achieve the government's policy and follow the advice. And I need to stick a pin in there. So because I listened very carefully for a little while to Attorney Rath, but I need to stick a pin here in this. When we took office, just in those few weeks, we were faced with 2 urgent matters that helped us to even accelerate the need to get this paper in. One was that we had a budget that didn't have much time left to pass. The second one was that we were losing our grounds in the cruise ship industry. And we had to go to the renowned conference known as it's slipping now. We're going to it soon in terms of sea trade. We call it sea trade. Sorry about that, senior moment. Sea trade. When we went to hold a meeting with the boards at that time to speak with them, the tourist board, we call a meeting with the tourist board, we call a meeting with the ports authority, we call a meeting with the airports authority. And we recognized there and then, because being in the opposition, I saw something happen for years. The tourist board went to sea trade with their own booth promoting the BVI. The ports authority went to the sea trade with their own booth to promote the BVI. And so if airports authority went, they went with their own. And there was a fourth one, which was a National Park Trust. What we were trying to establish is that there were too many duplications of efforts and what we will call monies that could hit the target better if they were amalgamated. To my surprise, we were told that that's the first time that all the boards met in any time that they could remember. The members that were there in the board stated that to us. So we, first of all, the listing going to sea trade was too huge, so we had to cut it down. And we had to get a oneness in purpose of why we are going to Miami to this sea trade and come under one umbrella. But it's in that meeting I recognized, listening, that each of them had a different goal to achieve, and that didn't reflect what we wanted to achieve. So we made a decision at that time to save money, bring focus to our product as a country, and also to allow for cohesiveness among boards, to have the chairperson of the tourist board automatically be a member of both the airports and the Ports Authority board, so that they can know what is happening up front. Likewise, the chairman of the ports board, we said now would have to serve on the airports and also the tourist board, and likewise the other board. So we created that triangle for all three. So you would find where persons were saying that the one person has so many boards, but it wasn't a person. But legally, why I say that is that when we went to do that legally, we were told that we have to put them by name for now, because they had the Attorney General told us we have to make amendments to allow that to be reflected in each one of the boards, whether policies or laws or statute. So do it by name. That has saved us significant savings and put us in a better direction. And that's why I said, to my understanding, was for the AG to advise us in any other case that what is lawful and what is not, to advise if any statutory amendments were required, which he said there, to legally achieve the government's policy and vision, which was to save money, bring us in oneness of purpose, and also allow for these other energizing areas of a youth, a Sister Island coordinator, a Sister Island person, because our Sister Islands always were left off of most of these. The issue that we had is up to now, until we make the legal changes, we can only put the person there by name. In terms of if they're from a Sister Island, they're not there as a Sister Island in some of our laws that have not been changed as yet. They're there as a person. The head of the tourist board is on the airports as a person, the person and not the post, but really supposed to be the post. So we did it that way for expediency, to come with the revisions of the law. That was the thrust behind what we were doing with boards, trying to amalgamate some of them and allow us to be able to move in a better direction. Which, Commissioner, as I listen, I would just end this part with this, that I would state that it's important for the record of COI that the board appointees to note that despite it all, they perform well. That's not the question right now. But hence the choices made have proven over the years, not just now under our government, to be well. And I strongly recommend, as a caveat to what you're doing, to request, even from this government and other governments, what has been the progress of the boards given their appointments, so that one can see that they're their processes and their way forward was in the public interest and not in a political party interest, because we now have started to try to build more towards institutions so that it will last and stand the test of time. So I think I needed to point that out in terms of the thrust behind the decision of where we were going with the boards, and that the AG merely consistently stated that the interpretation applied. But we asked specifically, are we violating any laws? And at no time were we given a definitive answer by the Attorney General, yes. So in Cabinet, you would appreciate this, Commissioner, that every decision you make is a risk. A person will go court for anything. So some risks are higher than the others. So that is the vein in which that was said. Now the chair spoke about political parties, but that wouldn't also be accurate, because time would show that there are persons who ran against us politically that made it to the boards. So that factor never weighed out to be accurate. It was something new and innovative that was not welcome in some quarters, but we had to do it to shake up things, to start to try to diversify the economy even more. And I would say, Chair, even more innovative was rotating deputy premiers. We decided that every 3 months, each one of the minister as premier would have a chance to act in the role as deputy premier. Some people don't agree up to today, but some thought it was innovative. But now I am confident that my other 4 ministers can hold the helm of premier if, God forbid, something happened, because the experience that they harness for that 3 months also was part of our campaign for change and unprecedented moves, as we call ourselves, one of the government, unconventional government. So I would just like to put that backdrop in there to add some flavor on what was the impetus behind why we were making some of these moves. So it was also financial.
Thank you for that, Premier. And that may in due course answer some other questions. But to go back to the question that Mr. Rawat put, he put, based on evidence that we've had from other ministers, 3 propositions as to this policy. One is that members of the board must have a commitment to your programme. Secondly, that youth, which is mentioned in paragraph 6.8 of the Cabinet Handbook in any event, but the prominence of youth was increased by having a youth, however that is defined on each board, and to have the tenure on statutory boards exactly coincident with the tenure of the administration. Those 3 propositions, do you accept that those are behind the policy?
Those are 3 with some of the others I name, yes.
Thank you. Thank you very much. Mr. Rawat.
You've explained to the Commissioner that prior to this March paper and then the discussion in Cabinet on the 27th, there was no preceding policy paper. So there's no other document where your policy is written down, is there?
No, other than what was manifesto in terms of a change and making some of these unprecedented moves.
Well, of the 3 points that both I and the Commissioner has put to you, the only thing that is specifically referred to in your manifesto in relation to statutory boards is youth inclusion.
Right.
But the point is that also when we look at those 2 documents, the paper you took to Cabinet and the deliberations, the first thing is that there's no reference in any of the discussion to sister island representation, is there? No,
it wasn't a discussion about sister island representation.
Can I pause you there for a moment, please? I need to also correct one thing. If you go to 2741, please, Premier, and you look at 19, in the course of your answer earlier to the Commissioner, you referred to the chair, and by that I took to mean the chairman as in the governor in this discussion, referring to political parties. But if you look at paragraph 19, it's right, isn't it? That's the minister for education, culture, agriculture, fisheries, sports and youth affairs that's referring to political parties. Because as I've read out, that minister states that commitment to the current government's mandate from the people must be paramount. Incorrect actions of the past and or an association with a former party or administration could have a real impact on how matters progressed. So this was from one of your own ministers, not from the governor, wasn't? Is that right?
Yes, but let us look at the chair's response from what you read earlier. Earlier, you referred to what the chair said.
I think it's probably, is it paragraph 21, Premier, bottom of page 2741, voicing his concerns.
Right.
The chairman said that the cabinet had wide discretionary powers, which should be used in accordance with the principles of administration. I think principles of good administration, and not without justifiable reasons. This, he said, risks undermining the cabinet's commitment to good administration and good governance. When you gave your long answer, I understand what you said there, but that is not an endorsement by the governor of this policy.
No, well, the governor endorsement of the policy, what we were coming with, you meant, in terms of what we have said, the 3 areas? Is that what you mean?
Well, that's a good question. The policy was not simply, we are going to reinvigorate statutory boards. You know, an understandable policy. It wasn't that. And that's why I took you to the purpose of the cabinet paper. The purpose of the cabinet paper was to remove the membership, all members of all statutory boards, except ex officio members. It was an integral part of your policy to remove all members of all boards.
Right, but that did not mean, one, that it was unlawful because the AG has not stated that, and two, it did not mean that persons who want them were not going to return. It was going to be a fresh look at it because there are persons on some of the boards that return.
The Attorney General who you've referred to, and Mr. Rowett read out the relevant parts of the deliberations, but in paragraph 7 on page 2739, this is what the AG said. The Attorney General said, in cases where any powers are conferred by the legislature, one should provide reasons for removal of persons, and suggested that it is better to provide reasons. The Attorney General advised that if this administration wants to be a government consistent with public administration, then reasons must be given for removal of members of boards. It doesn't say so expressly, but it seems to me to be read in there that the Attorney General did have some concerns about this policy.
Well, the Attorney General had some concerns about the process, but when asked, straight as clear as could be, is it unlawful? The Attorney General never gave us a direct answer that yes, it is. Had the Attorney General stated to us that at any stage that there was no lawful way by which we could have revoked the appointments of these boards on the basis of the new policy, we would have asked him to advise on how to proceed to achieve the government's policy and follow that advice. The Attorney General's job would have been, well, all right, you will have to bring back a paper to revoke statutory bodies or the measures on which statutory bodies will be appointed, revoked, etc. So we were asking him, what is your advice? Do you see it as unlawful? And we were never given a clear answer as yes, it is unlawful, and I cannot support it, and this is where you need to go. We are not lawyers.
I fully understand that answer, but Premier, you know lawyers, and lawyers very rarely will tell you, look, this is definitely unlawful, not a shadow of, this is an exercise of discretion. Doing it, it's definitely unlawful. Or it's definitely lawful because there's a scale. It comes through the papers that the Attorney General was concerned about this policy and the way it was being implemented.
Right, but Chair, with the utmost respect, he was asked, what was the legal risk? And he said that there was some legal risk that persons may go to court. And can they have legal recourse?
I'm sorry to interrupt. That's not what he was asked. It was put to him.
Yes.
People have legal recourse. Individuals.
Right, they put it to him.
Who were sacked, will they have legal recourse?
Right.
But that's not the only question where governance is concerned.
No, that's not the only question. But the issue here is, you said we know lawyers. Today, I must say that Mr. Rad and yourself, being in the legal field, are here to find out if the law was broken. So you're looking from me for a yes or no. So we were asking this Attorney General the same thing. Are we broken the law? Yes or no? And if he said no, it would have taken a different nomenclature. But we kept pressing, and it seemed like an on-the-fence answer. So had he come in the way you have come to see whether it was violated or not, we would have taken a different stand, because we would have had to respect the Attorney General that you said that this is the case. And we would have had to adjust ourselves. There were 1 or 2 times we had to. But for the most part, with most of these votes, the answer was never forthcoming as yes, you are violating the law, or no. So, and some of the persons that were on before, after we started to assess, and we even assessing some boards, 1 or 2 boards have, but 1 of them have not been reconstituted as yet, because we had to change or thinking as time passed. Being a younger government, you know, and any person, as time evolved, you will say, well, all right, I need to reassess my decision here. As you get going, you realize that in the public service structure, things don't move as fast as you were thinking. So to make sure that things going, I have to reassess and reanalyze. But the Attorney General's duty is to advise us legally. It is either yes or no, we are violating the law. And if it is yes, tell us how to go about achieving a policy. If it is no, well then fine. But if you stay on the fence and allow any politician to make his decision, they're going to make a decision, because that is what you got elected to do, to make decisions. So I cannot state that at any time, from what I was seeing and listening to the Attorney General, that it was advice that was either on the left of the fence or the right. It always seems like it was on the fence. So with due respect, because I like the former Attorney General, but I must say that it always seemed like it was on the fence and left it up to the discretion of ministers. Now, the chair raised clear concerns, which caused us to go to the Attorney General, who is the legal advisor, and say, well, all right, can you clear this up for us legally? Because the chair can have his preference of whether he agrees with the policy or not. But there should be no one with a preference whether it is legal or not. That's all I'm saying.
The policy, though, because it might be very difficult not to support the policy of an elected cabinet to reinvigorate statutory boards, or indeed reinvigorate anything. That's fine. And the governor in the papers makes it clear that he had no concerns about that as a policy. But that wasn't your policy. Your policy was to revoke all the membership of all statutory boards. That was your policy. And that was the point that was put, that was the policy that drew concerns from the governor. And on the basis of this, drew concerns given the reasons that you were putting forward from the Attorney General. And your response was to the governor, but the governor's concerns, I think, reflected those of the Attorney General. The Premier thanked the governor for noting his concern on the matter, but pointed out that the governor's definition of justifiable reasons differed from theirs, and immediately the appointment of all of the board members was revoked.
Thank you so much, Chair. Chair, there were discussions with the Attorney General in Cabinet, some captured in this minutes, some would not have been,
Except that.
and even before. And it was clear that the intent of the government was, given as a new government, to put some energy, some new energy into the boards, Sister Island representative, youth, etc. But what caused us to move in this direction? What caused us to move? The Attorney General was clear to us that you cannot put a post inside some of these boards saying youth representative, you will have to change the nomenclature of what makes up the board. You cannot put a person there in terms of being youth. You have to change the nomenclature of how whether it be the law, the policy, or whatever, the statute, whichever one was governing the board. So you can't just do it like that. So when we asked what has to be done, they said, well, you would have to change the law for each board so that you can do that. Later on, we learned with experience that we could have done a overall statutory board legislation to govern boards and rescind some of them. We learned that almost a year and a half later. But given that we could not do that, and we were told also with the added extra area that we wanted to put chairpersons of certain boards and other boards, he stated to us that we cannot do that neither, because in our conversations, because the nomenclature of the act or the policy or the statute doesn't allow. So we told him, well, okay, so that now caused us to bring to the conclusion that the one thing to do is to revoke the members from the board and then put the persons on by name rather than by post. So you will find someone on that is from a sister island, but we couldn't name sister island representative because the legal framework didn't allow for those wordings. Or you'll find someone that was from the tourist board on as a chair on the other one, but we couldn't put them by post because the legal structure didn't allow for it. So we wanted to reconstitute the board based on what we were doing, but the advice that was coming forward was telling us what all we couldn't do. And what we are asked is tell us what we can do so that we can get to this path. But we were never given that advice. We were left on the fence. Even when we revoked the members, I understand clearly that there were concerns. I might be concerned over something, Commissioner, or you may be concerned over something, but the question is, the concern that you're raising, is it a legal concern or a preference, one of preference? Well, all is we're asking the Attorney General of the day, is it a legal issue? Is it unlawful to do what we are asking to do, or is it lawful? And all we needed was a yes or a no, because we would not do anything knowingly, especially even now as we mature more. And even then, that would have violated the law. That's never our intent.
But even the statutes, as it were, the mother statutes, as they stood, they did not prohibit you from putting youths on. They did not prohibit you from putting the chairman of one board onto another board. They didn't mandate it, they didn't require it, but they didn't prohibit it. Right. So that on any board, when there was a vacancy, you could look at the vacancy, look at the board. Is there a youth on the board already? If not, then favour a youth for that particular position. But there's nothing wrong with that. Sacking the entire board doesn't put you in any better position, does it? How can it put you in any better position?
Well, it wouldn't. And that the sacking the board is a little strong word. I can't use those words. I would say reconstituting the board is what we are about. And
I'm sorry, but just I appreciate that you don't like the word sacking, but this policy was to revoke the membership of all of the boards except the ex officio members who we can leave out of it.
Right.
And then, of course, there were boards, so you had to reconstitute the board then. But the policy was not simply to jiggle around with the constitution of the boards, it was to get rid of the boards. That was the policy.
No, the policy was to reconstruct the board, reconstitute the boards to reflect what we wanted to do. And I explain it because some persons have the mindset, and it's noteworthy, that you should not remove the entire persons from the board because you will lose the knowledge and also the what you would call the balance over time. But we have to remember that institutional knowledge is with the ministries. You have the ex officio members there for a reason. The ex officio members will be the permanent secretary or whoever his or her designate is, whichever public officer that would attend. And they would have minutes. And you cannot underestimate the institutional knowledge that lie within the public service. The ministry with the minister are the ones to do the policy, but the board help to flesh it out. And when ministers come into office, no matter who the government of the day is, they rely on the institutional knowledge which comes from the public service and government, because that is the only sector that is continuum. Membership in boards come and go, members come and go, elected officials come and go, but the public service remains constant. So is the one continuum. So with that now, those are the ones who are going to have all the records. Those are the ones who are going to have all the minutes. Those are the ones who have all the institutional knowledge to guide ministers, which of course will also come by the same governor and deputy governor and permanent secretaries and even the attorney general office as guide ministers. So if ministers come, no matter who the government is, with a policy that I want to reconstitute the board in a different nomenclature, then the foundation of the board, which is the institutional knowledge, would be available to whoever takes up the post. What was missing, which is now being worked on by the Premier's office as a pilot project, is in terms of what are known as your responsibilities as a board member, what it is that that once you say yes, what are you saying yes to? That is why we're evolving from the informal stage now to reach to the next level, which our people are working on, to add in the advertising, add in clearly what each board member is expected of you, so that when you take up or consider the post, what do you have? But the institutional knowledge is in the ministries. It is with the public officers, and that's why they're so valuable to us. And that we have to continue to work towards letting them evolve also, while we're working together now with the Deputy Governor and Governor's Office with the transformation of the public service, because the country now is evolving into a next level. We're moving into a new paradigm shift. Some of these areas were not done because of how our culture was going through the years of 71 years of legislative council, but our population has grown. And therefore, how we institutionalize things and how we deal with things have to evolve. And that's what we're doing now. So when we came in, we were trying to jumpstart that, because when I came as minister, there's also a speech, and I'm sure that within the model is somewhere there, where I stated clearly that we inherited a public service that's not modernized to deal with the modern events and chain of events that we have to deal with. Nothing against the public officers, but we recognize that they weren't given that expertise. We were told in the 2012 white paper that the training for our public officers would have happened by the UK. It never happened. So we continue to train ourselves. And over the years, we have recognized where we need to improve, but we also recognize the area where we have improved. And now going out to advertisements and other areas of where we are proposing, which in terms of certain legal help for each ministry, also the ethics unit for the cabinet office. These are things that we are proposing that should have been in place from 2015, 20 years ago of our existence by the same governor's office and those that were helping us and by the white paper to move forward, but they were not there. So we build ourselves. Now we're building ourselves to go into a new level with our public officers who work so hard to get us there. So that's why I mean by our shift was one that I cannot say that the governor would have approved, but at the same time, two policies of a government might not get approval of a governor. But at the same time, the question is the policy in the best interest of the public? The question is, is it? And the other question is it lawful or is it not? And the only person can answer that for any sitting government is the Attorney General. And if we cannot get a yes or a no, then you leave the sitting government, whomever they are, in a quandary to decide on their own. So you cannot wait until we decide and then come and tell us, well, there's an error because we asked you before we decided. So we are not lawyers. And the reason I'm here today, Commissioner, is because you want to know if we acted unlawfully. And I'm here to tell you As far as I'm seeing, we didn't because we were not given advice that we did.
It's to ask the questions posed by the terms of reference. But my difficulty is, before the Attorney General was involved in this, you, within days of coming into office, had a policy to sack or remove all members of all boards except ex officio members. And I am struggling to see what you considered the public benefit was in doing that. If you wanted to reinvigorate the boards, there are a number of ways of doing it, but that did not include sacking all members of all boards.
Well, thank you, Commissioner. I really have to thank you for your view of it because you're probably looking at it from a different lens, most likely. Sack is a heavy word. It wasn't sack, reconstitute. We look at it and the evidence of what has happened can only be borne out by looking now at what the boards did because we have a 2-year history now. And the achievements of the board would have to bear out whether or not it was in the public's interest or not. That is the only measuring stick that any one of us would have because the actions have to speak louder than the word.
With respect, and again, I'm sorry to interrupt, that may be an indicator, of course, but don't we have to look at the decision you made, your cabinet made, a policy decision to revoke the membership of all of the boards?
Exactly.
But is it? And I am struggling to see why you made that policy decision and why you didn't make a policy decision to reinvigorate the boards and then investigate how best that could be done.
Well, I would say to you, so, Commissioner, through the lens of a public officer, you have 25 years before pension. Through the lens of elected officials, you have 4 or 5. So you have to make your mark in the public's interest in the best way that you see fit, not personal towards anyone. You will see as we get to other boards that persons that supported parties that ran against us are on those boards. So obviously it was not a political decision.
Not a party political decision.
Not a party political decision or political at all. It was one in which we wanted to rejuvenate the boards and also to try to get boards to think differently in terms of paradigm shift and to save monies. We were faced where each board was acting in a silo. And if you ask each of them the question of where the BVI was going, each had a different answer. So we wanted to shake up things and get us moving as a country in one direction. And some of the members that were on there before did return.
Thank you very much, Premier. I'm sorry, Mr. Rawat.
Premier, you've taken us into areas which are some distance away from the issue that we're concerned with, which is a policy of revocation. If you go back to 2930, as part of your long disquisition to the Commissioner, you have touched back on the recruitment process. You have touched on transforming the civil service. What I'd really like to get back to is the question that I was putting to you. If you look at paragraph 7, the purpose of this paper, and it's an important paper, Premier, because this is the first intimation of the policy. There's nothing before that. Nothing has been provided to the COI to show anything before that. And what you say is that the purpose is to dissolve current board membership and appoint new board members. There's no rejuvenate, there's no reconstitute. And when one looks at other decisions, and we will may need to look at them when we go to individual boards, again, the word reconstitute does not appear. The word remove does, the word revoke does. And this paper is headed revocation.
Right.
So that's what we are concerned with. Now, I just want to take you back to 2739, please. Because both in the written response from yourself and indeed Honourable Malone and Honourable Wheatley and the Cabinet, there is what must be identified as criticism as to the conduct of the Attorney General, the former Attorney General. Now, if we look at this 2739, you started off saying that the Attorney General was pressed by the Cabinet as to whether the policy, and we've given the 3 headings of that policy, was unlawful. Could you just direct the Commissioner's attention to which paragraph, from paragraph 3 through to paragraph 22, you rely on as evidence of the Cabinet pressing the Attorney General in March 2019 for clarification?
But could you show me where he didn't clarify, where he did clarify?
No, Premier, your evidence was that the Cabinet, not just yourself, all
Right.
5 members of the Cabinet pressed the Attorney General for clarity. I would just like you to point the Commissioner's attention to where you did that.
Commissioner, there's one of the things that I need to make clear. In a Cabinet meeting, the gist of the conversations was captured, but there's so much more that's discussed that is not inside of these. So there was a long discussion on are we acting lawful or unlawful? That is what precipitated the Attorney General to say the Attorney General, the chairman stated a specific reason in 4, or a reasonable justification should be given to remove persons as members of a board. He asked if there was sufficient reason in this regard. The Attorney General didn't respond just like that. The chairman, after he said that, my recollection was there were some discussions about it. Now, we would not capture all of that in the minutes.
Pause there for a moment. Is it your evidence, Premier, that this long discussion about the legality of a policy that subsequently informed decisions you made about a number of statutory boards, not just under your umbrella, that this long discussion where you and fellow Cabinet members pressed the AG for clarification was not recorded on this day?
Well, I'll put it this for you, it wasn't recorded in the paper. You're taking me to the end,
No.
but in preparation of the paper, Attorney, with due respect, we're not lawyers. When we do these Cabinet papers up, we send them to the Attorney General's office through the public officials, requesting to make sure that all the areas, whatever box needs to be checked is checked. If this is flagged at that time by the legal officials of the government, which is the Attorney General, that you cannot move forward because this is unlawful, the paper would not even reach to the Cabinet because the adjustments would have to be made. And if we decide that we're going to push it towards Cabinet, then we understand the risk that we're up against. For most of these papers, this has been the case where no adverse legal thing would have been cited, or if they're cited, it was one in which that you would call and ask, AG, what do you mean by this? Are you saying it's lawful or are you saying it's not? And at no time we got that clear answer. There's nothing else I could say.
But page 2930, this is the your Cabinet paper. As you say, we've seen many Cabinet papers and the legal implications, although this is headed financial implications, this is clearly from the Attorney General, but the legal implications section simply says no adverse implications of this proposal foreseen or something like that. But this, without saying in terms, this is definitely going to be unlawful, clearly indicates that it's a risk. The Attorney General, when he gave this opinion, knew the basis of the policy because it's in the paper, so far as it exists, it's in the paper. And he has obviously got a considerable concern about the Cabinet exercising its discretion in the manner it proposes to do.
Commissioner, that is clear for anything that you do in Cabinet, that they're going to have risk, whether by the Attorney General saying so or otherwise. But what we are asking is clear. I'm here today for a specific reason, and your reason is clear to me. Did we act lawfully or unlawfully in our actions with removing persons from the board? That is clear. So the Attorney General 2 years ago should have advised us when we asked clearly, even in the informal conversations, are we acting lawful or unlawful with this? Look at one of the notes from the Attorney General. May I note further that there is no provision for revoking the appointment of members of the Tourist Board. This is in 2931. But that it is cured by Section 20 of the Interpretation Act, Cap 136, which authorizes an appointment authority to remove an appointee at his discretion. This, of course, entails compliance with the rule of law requirement I had previously made reference to. This is tantamount to going to the doctor and asking, well, how do I get cured? And he said, well, all right, if you go and look up a few tablets and the one that you see that matches what I feel here, then use it. Doctor, will this help me? Is this going to cure me? Yes or no? I like when we deal with these kind of matters to give me a concrete answer. You're my lawyer. My lawyer left me leaving to interpret this. May I note further, there is no provisions for revoking the appointment of members of the Trust Tourist Board. Well, if there's no provisions for revoking the appointment, that means it's open. That is my interpretation, because you didn't interpret it for me. But that is cured by Section 20 of the Interpretation Act, Cap 136, which authorizes an appointing authority to remove an appointee at his discretion. I went and I checked that. I still didn't find from my layman term anything to state, well, you cannot move in this direction, because I didn't get a clear answer. This, of course, entails compliance with the rule of law I had previously made reference to. Now, Commissioner, you being a lawyer would understand this legal language, but I major in the sciences. I just want, are we acting illegal or are we acting legal? It's a yes or no. This one here is on the fence. And that is what I'm saying, that most of the legal thing in the past, when we got them, were just basically saying there were no adverse legal implications. And then when we go in cabinet, if the chair raises something, it becomes a discussion. But what do I do if my lawyer don't give me a yes or a no? And when he gives it to me, give me the reason. How do we move forward? We're running a country. How do we move forward? If it's yes, tell me, how do we get it done? This is what we want. I would say, Mr. Rat, you do have a good point.
Can I take you back to that paragraph before we lose it?
Yes.
Is that paragraph that you pointed out at 2931, is that your example of what you had earlier described to the Commissioner as the Attorney General's on-the-fence answer? Is that the on-the-fence answer?
This one to me?
Yes. That's the on-the-fence answer.
This is one of them.
Let's go back to the deliberations.
Yeah.
Because with all respect to you, Premier,
yeah,
your answers are inconsistent.
Mm-hmm.
Because first of all, you described a cabinet meeting where the AG is pressed by all five of you for clarification.
Right.
But you cannot point to a single paragraph which shows any one of you pressing him for clarification.
Mm-hmm. Well, I would say
so what the Commissioner has to conclude on your evidence is that this discussion about a policy right at the beginning of your administration, which was going to have wide-ranging impact, was not recorded in the cabinet minute. Is that right?
Well, Mr. Rudd, I would say that my answer is inconsistent. You just don't like my answer.
No, the reason it's inconsistent is because subsequently, instead of you moved from a discussion in cabinet, you're referring to the informal process. And that's what I need to break down.
No, but I'm saying clear, and I would say 50 times. The basis of moving forward a cabinet paper is the legal implications that's given to you. If this is before you reach the cabinet.
Are you now saying that cabinet, all five of you, pressed the Attorney General for clarification of the position prior to the submission of that paper to cabinet?
Not that we pressed it in the cabinet, we had discussions about it.
Right. Well, this is where the confusion is arising.
Yes.
And we need to break it down.
Yes.
So prior to submission of the cabinet paper, there was no discussion with the Attorney General, save that what we see in the cabinet paper itself. Is that right?
The discussion, no, we wouldn't have had a discussion on all five of us.
So then you
but you have to allow me, you stating and you going on. Why would you have other discussions that something is illegal when the comments posted on the paper does not lead you to say, well, all right, we shouldn't do this at all? That is your impetus to move forward.
Premier, you've given that answer. I just want to get the evidence clear.
Yeah.
Right? So you've given the answer. The Commissioner has seen the paper He's drawn your attention himself to the advice that the AG put into that paper, and you've commented on it. Let's move to the cabinet meeting.
Certainly.
The cabinet meeting is at 2739. Is it your position that in that cabinet meeting, because that's what I understood your evidence to be earlier, 5 members of the cabinet pressed the Attorney General with one simple question: is it lawful or unlawful?
I can't say with one simple question. It was a series of discussion.
That was earlier. That
Yes,
was your
but
evidence.
I asked that. We had that clearly. We had that clearly.
In terms.
Right.
But that isn't recorded anywhere in these paragraphs.
But Mr.
And so does that mean that this important discussion was simply not recorded in the cabinet minutes?
Mr. Wright, I can't tell you what was called or not based on what's here. All I could tell you, let me phrase it correctly. You can't capture everything that happens in the cabinet meeting in the minutes. That's impossible anywhere in the world. The discussion that ensued after the chair part of what he said caused a flurry of discussions. What the cabinet secretary will do is capture the essence of it inside of it and put it down.
I understand.
So that's all I'm saying.
But if I understand your evidence, just to go back half a step, the policy was to revoke the membership of statutory boards and then reconstitute. That was the policy.
That is a policy you were trying to walk from.
Yes. And my understanding is that that was the policy that you were going to pursue unless the Attorney General said that is unlawful, full stop.
Right, but inside of there also that wasn't all the way captured because we went there for a long time on this. We could not get the reconstituting of the board in the manner that we were saying because the Attorney General, that's not captured here, but I show you get any minister that'll tell you this. The Attorney General stated clearly that some of those things that you want would cause for you to have to reconfigure whether the law or the statute.
Sorry, I understand that point.
Right.
But in terms of revocation, that was the stance of you and the cabinet. And the concern that was expressed both by the Attorney General and the Governor was that for the reasons you'd given to take this step, which I have to say, you say it's innovative. It seems to me to be, on the face of it, a fairly odd and curious step. But to take this step, the reasons that were being given did not or may not pass muster. That's their concern. And so, I mean, analogies always fall apart, certainly in my hands, but it's the equivalent of you going to a doctor and saying, well, you should take these pills, but you not taking them unless you're going to suffer death. I mean, it's the analogy does not work. In these circumstances, you were going to do something, you say, innovative. I would say that it was certainly curious. And the Attorney General and the Governor expressed concerns about the reasons that were being relied upon in the Cabinet to take this decision.
Commissioner, I hear you, but the aim of all of this was deeply vested in a positive move of public interest. And I thank you for the analogy of the doctor, because if the doctor gives you some tablet until you take this, or chances are that you might die if you don't. I think that the doctor is saying, take it. Here now we're saying, all we needed as a young government is not to receive what I would call a most standard response, not to receive assumptions about some boards being applied what being applied across boards, or whether persons agree with the policy. If persons don't agree with policy, that's democracy. That's your right to democracy. But the question is it lawful or not? That's all we needed to know. And to whatever else I say, I'll always have to stick to that, because if we were told otherwise, we would have had other conversations. I just don't know how else to put it. A lawyer's job is to tell its client if it is right or not. We have got cases now with our Attorney General that we have now, and she said, clear, this is where I stand, this is what it is. It is then at that time up to the government to decide what they'll do, because you were given a clear stance by legal opinion by the attorney.
And for the cabinet then to take the risk.
And it's for the cabinet then to decide if they're taking the risk. That's all I'm saying.
I understand that. But can you see this? That there could be a perception that a new government, a new administration coming into power, and within days of doing so, sacking, which is a word I do use now, all of the members of all statutory boards, which are set up to be independent, autonomous, and to do the functions that the House of Assembly is assigned to them, could be construed as a political act.
Not at all.
I use the word perception. I understand your evidence that it was not.
It would seem so to some, but then as you move forward, it does not bear out to be a political action, because some of the very persons who had political differences ended up on the boards. Some of the very persons for some of all these boards are in the government and right back up on the board. So the evidence in the long run, or even in the short run, after persons were appointed, does not bear out for it to be political. It was one in terms of shaking up things and getting things moved. I know you say an analogy. I know about a case where a judge started and he said, I give myself 6 months. That was letting the whole atmosphere know where I'm standing today when it comes to anything right or wrong. So we were sending a clear message that we want to rejuvenate, re-energize, bring some more dynamics to the board, given that we have a short window to diversify our economy.
No, I understand. I understand the answer, Premier. Thank you very much. Mr. Rawa, firstly, it's 1:15. That doesn't mean to say I'm going to stop you immediately. Are we near the end of this particular topic?
Just a couple of questions just on this. Premier, I understand what you said about discussions that you recall taking place that were not recorded in the Cabinet minutes. But if we go to 2739 and look at 7, please. The AG's advice in Cabinet was one should provide reasons for removal of persons, and then at the end, reasons must be given for removal of members of the board. Now, the decision that Cabinet took on that day was to revoke all members except the ex officio members of 2 boards, and that was with immediate effect: the BVI Tourist Board and the BVI Ports Authority. So there aren't, as I can see in there, the reasons that are recorded for that removal of those 2 boards. So we must take it, mustn't it, that it is based on that policy as outlined in the Cabinet paper that you brought forward?
That was one of the thrusts behind of it. The other thrust behind of it was that we were moving towards having to look about going away to sea trade and some other things that were coming up. And those 2 boards and the airport were crucial for us to get done. So those are the reasons those were moved on first.
You've explained about sea trade. The difficulty is that there is no mention of sea trade in the Cabinet minutes as recording it as part of the reasons for it. And secondly, there's no mention of sea trade in the Cabinet paper. All that the Cabinet paper helps us with when we look for reasons why you and the Cabinet took these decisions is that it is based on your policy, which I've outlined the 3 elements of that policy. And that was the reasoning, wasn't it, for this decision?
Yeah, Mr. Red, I understand you're trying to ask me that direct question, but please allow me, Chair, Commissioner, to say something. All public officers are evolving on writing of Cabinet papers. And as a young government, you come in and yes, the purpose is the revocation. And if I had it to do it over again, watching it, knowing as you mature into these ministries and the importance of setting the policy up and why that you would move in this course of action because of the policy setting it up. The papers would have been written differently and advised to be written differently. but that's not a fault of the ministers. That's what I'm saying, that from 2012, when the white paper said that they're going to strengthen our people in the areas that were weak, they would never receive that help. So we had to do it on our own. So with that in mind, some of the things that I see now, we would have phrased them differently, knowing that if someone take it up, this is what we'll be looking for. Because we, even as we mature, recognize that we would send back certain cabinet papers to say, well, wait, it doesn't reflect exactly what we were saying. A young government, they just want to see the paper. Yeah, it has it on. Well, all right, well, let's pass it, let's move on. So it wasn't done out of any bad intentions, only the public interest. It wasn't done definitely to violate any laws. But in answering the attorney, yes, the Attorney General said that, but again, at the same time too, we read where he said that there was no law for revocation. So you're seeing one thing one way, one thing the next by the Attorney General, and all you want is a yes or no. Sorry to be redundant, but that's all I wanted, a yes or no.
Premier, I think I was trying to move the questions on the topic forward. It was about trying to identify what my questions are focused to is the basis on which the decision was taken on the 27th of March 2019. Mm-hmm. And it's trying to identify that from the contemporaneous documents. The contemporaneous documents that we have are the cabinet paper and the cabinet minutes. Right. They record, what we can identify from those is what the Attorney General asked you to do, which was to give reasons. And when we go to the decision that is made by Cabinet, one cannot see the reasons. And all I'm putting to you is, does it not follow that the basis on which these two boards were revoked was that the policy as enumerated in that paper?
But the Attorney General didn't say to give reasons. Again, let us read what the Attorney General said. The Attorney General said, in cases where any powers are conferred by the legislature, one should provide reasons for removal of persons, and suggested that it is better to provide reasons. So he suggested that it would be better to provide reasons. That ensued another discussion. As you can see, the AG advised if this administration wants to be a government consistent with public administration, then reasons must be given for removal of boards of board members. Members asked if there were any precedent of unreasonable exercise, and you already read all of that, and we went through all of that. All of that ensued a discussion. Are we acting lawfully or not?
Premier, all I'm asking you, please, is just to confirm that the reasons that the Cabinet applied to this decision were those set out in your Cabinet paper, namely the three heads of your policy. You revoked those boards because you wanted to have, going forward, to have boards that had a membership that showed a commitment to the administration's programs, boards that had a youth representative on it, at least, and boards that had a tenure that matched your administration. And in order to take that policy forward, that was the reason you made the decision in respect of those two boards on the 27th of March. That is, please, a yes or no question.
I don't think that you could ask me and tell me how to answer, with due respect. The impetus on it was that, but there was more discussions. Because if I come to give witness for evidence on something that we are being accused, I have to bring everything to the table to clear my name. We had a lot, we're doing a lot of work on a daily basis. There's a lot of meetings that didn't fall within the confines of this paper that help us to reach here. So I'm bringing context to the text that you're asking me to read. There's a lot of context with meetings, with boards, etc., where things are not going good, where you recognize that you have to shake up things. So to just state those are the only reasons, yes, those are some of the reasons, but there are also some background information that you do not have, but I have it. And while I'm testifying, I have to bring it to the table and put it on the record that these were some of the areas that we are looking at. So the answer is yes, those are some of the areas, but it came as a result of some other measures.
You've given that context more than once. Just
for a reason.
With this, please, from paragraphs 3 to 22, identify the reasons that the Cabinet gave recorded on the cabinet minute for making its decision?
From paragraph 3,
Through to 22, let's go into 23. That's the entirety of the recorded minutes about this topic. Where are the reasons recorded for cabinet's decision?
Attorney, if I had this part to do over, I would have, and we were guided as young ministers, I'd have put some other things in the paper. So I'm telling you as truthful could be, I'm speaking truth to power and I'm speaking power in the truth. The reasons I've stated over and over, should there have been more profound in the paper? Yes. But in the archives of what's happening in the ministry, the thrust behind why we were doing it was what I told you. So yes, it would have been the removal of the members, but it wasn't just a blanket removal. There was something happening before why we were moving in that direction, which I've explained. I just want that done on the record because I do not want to answer something that when the report comes out, they said I answer yes, and the reasons that it is did not make it.
No, I mean, a couple of points, Premier, before we break. Firstly, I well understand the limitations of cabinet minutes, and one has to read cabinet minutes with caution because they cannot capture every single thing that was said. On the other hand, in terms of reasons for making the decision, we have to look at what's in really the cabinet memo, and the reasons are as Mr. Rawat set out. No other reasons are added in the deliberations. Some of the reasons in the paper are reiterated by you, for example, in paragraph 15. And it was those reasons which were relied upon by the cabinet, those reasons which the attorney expressed concern about, and those reasons which the governor expressed concern about. Your evidence is you took those concerns into account, you took the risks into account, and determined that in respect of these two boards, all of the members should go.
Yes, Commissioner, but we also took into account that the Attorney General did not give us a clear answer.
The Attorney General did not say in terms that if you proceeded with this, it was unlawful in any circumstances.
Exactly.
I accept that. Now, is that a convenient time for a break, Mr. Rawat?
Yes, Commissioner, I think it is.
Now,
I wonder, Commissioner, if I might just intervene because I shan't be here this afternoon. Will you be inviting submissions on these matters? A lot has been said about the proper way in which an Attorney General should advise a cabinet, and a lot has been said about legal risk. I mean, ministers, as you know, Commissioner, take legal risks all the time in the decisions that they make, either singly or collectively.
Sir Geoffrey, I don't need submissions on that. Because that's,
but there may be other matters, and I wondered whether, I mean, for example, an Attorney General might well be expected to tell his colleagues that there was no respectable argument that something was lawful. And indeed, I would have expected an Attorney General to do so if that's what he thought. But that isn't reflected anywhere here. So I think it would be, I mean, it may be that you don't wish to help, but it might be helpful to supply some submissions on these questions. I mean, it is the case that an Attorney General will tell the Cabinet if he thinks there is no respectable argument that something is lawful. And if he doesn't, frankly, he's not carrying out his duty. I mean, these are matters that are important because they supply context. Your inquiry at the moment has Mr. Rawat to ask questions that may or may not be open and balanced. And frankly, the discussions you've had this morning seem to me to require a degree of balance, Commissioner, and I invite you to consider submissions at the end.
Well, firstly, I certainly don't accept that any of the questions have been...
Well, I'm not asking you to accept it. Nor am I making a submission. I said they may or may not be, but certainly what would be helpful, I would submit to you, would be a perspective. Now, I may well be, sir, that you have that perspective well in mind. Indeed, frankly, I would be pretty confident that you do, but just in case, it might, I'm asking whether you would be wish to hear submissions or indeed to receive them in writing. at some later stage?
Well, that's something dealing with each topic, Jeffrey, that I always have in mind.
Great, thank you.
And this may well be a topic where
It would be helpful.
you would wish to put in submission, and they may be helpful. I would obviously want submissions and not, yes, let me give that some thought.
Well, if you would, sir, it's simply that there are certain matters here that I wonder whether wouldn't benefit. A witness in the box, particularly not a lawyer, can have questions fired at them, perfectly reasonable questions, and I say no other, but where errors can be made, and with a degree of reflection, perhaps a better picture can be put before you.
So Jeffrey, I understand that. What you say is that you may want to put submissions to put the Premier's evidence into context, and you may be right. Let me give that some thought. And
if you'd be so kind, I'm most grateful. And would you forgive me for not being present this afternoon? I'm afraid I have compelling other commitments, but Miss Peaty will be here.
I know, and that was explained this morning.
I'm most grateful. Forgive my absence during some of the morning, I'm afraid.
Yes, thank you very much. Good. Can we break until 2 o'clock, Premier? That doesn't give us very much time, but
What happens if I say no?
I'll always take it into account, Premier. But if half an hour is enough time, I know that you'll have other things to do, and we'll come back at 2 o'clock. Premier, thank you very much.
Thank you so much.
Thank you.
Yes, we're ready to resume. Thank you.
Thank you. Thank you, Commissioner. Premier, thank you for returning. Can we just go through the warning letters now? You should have to your left a paginated copy of the warning letter to you as Premier and a paginated copy of that to Cabinet. Commissioner, with your permission, what I propose to do is use the letter to the Premier, because some of the criticisms made, or potential criticisms made as against the office of Premier, are also made against Cabinet. The answers are the same. And so what I propose to do is just, for the record, cross-refer to the Cabinet letter as and when it appears necessary to do so. So Premier, if you turn to the letter to you, please, at page 1, you should have a box headed BVI Electricity Corporation. Do you have that?
Yes, sir.
The way the response is laid out is that it first sets out the potential criticism, and under each criticism it deals with the response. So if there is quite a lot of detail in the response, and I would like just to try and avoid going into too much detail unless it's necessary, because this does form part of the evidence already before the Commissioner. The way I will do it is to try and take board by board and just ask you some additional questions on it. If we take the BVI Electricity Corporation, which comes under your portfolio, there are 4 criticisms made. And for the record, Commissioner, criticisms 1 to 3 appear in the Cabinet letter, and the responses there are the same. The first criticism, Premier, goes to the decision to revoke the membership of the board of the BVI Corporation, which was made on the 25th of March 2019 and was effective on the 22nd of April 2019. The effect of that decision was that, with the exception of 1 person, all other members of the board, which was 5 individuals, had their appointments revoked. And by revoked, I mean prior to the expiry of their term of appointment. And that was effective from the 29th of April. It should be from the 29th of April 2019. If we look at the background, if you go, you should have part 3 with you, Premier. If you go please to page 2820, forgive me. 2820 in part 3, the part that we were looking at before the lunchtime break.
Gotcha. Two,
2820, please.
228.
2820.
Okay, thank you. 2820.
We have a paper dated the 25th of March 2019. That is the paper that was taken to Cabinet, headed revocation of appointments of board members, British Virgin Islands Electricity Corporation. Do you have that, Premier?
Yes, sir.
Now, at that time, it's a paper coming from the Ministry of Transportation, Works and Utilities, because it wasn't, as Dr. O'Neill's second affidavit confirms, until the 3rd of September 2019 that this statutory board was transferred to your portfolio. The background information sets out the law. There is a Electricity Corporation Ordinance which stipulates in part the membership and constitution of the corporation. And And if you look at 2, what section 5 of the ordinance states is that the chairman and or any appointed member of the corporation may resign his office by notice in writing addressed to cabinet and may be removed from office by cabinet in its discretion at any time. So cabinet has a discretionary power to remove a board member. If you go through to 2822, 7, the purpose of the paper was recorded as to revoke the appointment of appointed board members of the British Virgin Islands Electricity Corporation. And what we see at 2823 under legal implications is the advice from the Attorney General's Chambers, which notes that there's no express provision in the Act for the dissolution of the board of the corporation, but Cabinet has a discretion to revoke. And then it continues, however, in exercising its discretion to revoke the appointment of the members of the board, Cabinet must comply with one of essential requirements of the rule of law identified by Lord Bingham, namely that a discretion conferred by statutes on, quote, ministers and other public officials must be exercised reasonably, open brackets, rationally, close brackets, in good faith, and for the purpose for which the power was conferred, and without exceeding the limit of such powers. It continues, the concept of reasonableness is defined by its opposite, namely Wensbury unreasonableness. A decision is said, and there should be a by there, by Lord Diplock, to be unreasonable, open bracket, irrational, close bracket, if, quote, it is so outrageous in its defiance of either logic or morals that no sensible person could arrive at that conclusion on proper application of his mind. Now that was the background to the paper. If you go to 2827, please. We see there the Cabinet minute. It's an extract from the Cabinet minutes of that day dealing just with this paper. And as it says at 45, it was presented by the Minister for Transport Works and Utilities. And it continues at 46. Regarding the caption paper, the Premier reminded the Cabinet that he would introduce a policy stipulating that no members of board would be appointed for a duration beyond the terms / tenure of this administration. At 47, the Chairman reminded the Premier that justifiable reasons should be given to revoke the appointment of members of a board. 48, the AG said that discretion is given to Cabinet to revoke and appoint. Therefore, a decision should be reflected about why the appointments are being revoked. 49, in response to the Chairman's comment about providing justifiable reasons for revoking appointments, the Premier reiterated his position that he would establish a new policy that the terms of a board would not extend beyond the term of the government. At 50, the Chairman reiterated his position on the importance of having justifiable reasons to revoke memberships. At 51, the Premier reiterated his government's position that new policy was established that reflects the terms of a board members would not extend beyond the term of, spoke of the need to look at things holistically and that members appointed to board should represent who recommends their appointment. At 52, the Minister for Health and Social Development stated that it would be deemed as counterproductive to have board members who publicly participated in political campaigns contrary to the code of conduct they aspired to continuously serve on boards during this administration. At 53, the Attorney General said that based on statutory, and then it just reads RE dot, the AG said that the policy would have some challenges because some legislation stated that revocation is made based on specific reasons. The Premier said that all board members sign up to a code of conduct not to participate in political activity. Those would have violated the, and there's a typo, but it should read the code of conduct. And then Cabinet then decided in its discretion that the appointments of a number of board members of the corporation would be revoked, as it says, effective 22nd of April. And those members were 5 in total, leaving just 1 member left on the board. That's the background to this. If we return, please, Premier, to the warning letter and the criticisms and your answers, if we can look at those relatively quickly and just perhaps perhaps some additional detail in response on the response in terms of clarification. What was set out was the justification for the revocation, which is that the corporation had achieved a goal of completing phase 5 development and divesting to renewable sources of energy. The government now has a new mandate which necessitates revamping the board membership, coupled with a new strategic goal of ensuring that there is adequate and consistent supply of electricity for homes and business 24/7. Cabinet members are asked to consider and concur with the decision sought. That was in the paper we looked at. And then it refers to a broader policy set out in the following terms by you as Premier. Quote, a new government has assumed office with a new mandate, and as a result, he has decided to reassess the membership of all boards in a manner that will allow the mandate given by the people to be expedited in a transparent and accountable manner. Furthermore, the Premier stated that he would be recommending a policy that the membership on boards would extend for the duration of the administrative term in office. The criticisms that are made, and I will paraphrase, firstly, that the reasons that were recorded for immediate revocation were insufficient. Secondly, that there was insufficient or no regard to section 4B of the ordinance, which says that when making appointments, they should be made having taken into account the desirability of such interests as are affected by the corporation's activities being represented. Third, that the revocation of membership failed to adequately provide for independent expertise and oversight of the board. Fourth, that the policy of revoking membership with every new administration fails to adequately provide for independent expertise and oversight of all such boards. And the last one is that the decision to replace all of the members of the board failed to take into account legal advice indicating that the policy of replacing the membership of statutory boards with every new administration may be unconstitutional. Now, your response, if we can try and break it down a little, you start off by saying there was nothing to stop the Cabinet from adopting the policy. Now, again, when we refer to policy here, are we referring to the policy that we summarised before the lunchtime break, the new policy that your administration brought in when it came into office?
At that time, that is what we was kept stating and asking for the direction to help us legally to get to it.
And you continue, if we see, the legal advice was couched in equivocal terms and referred to a risk of conflict with the Constitution. Which particular legal advice were you referring to?
Well, from the Attorney General. The Attorney General did not come out. We're going to go back into the same thing. The decision to replace all members of the board failed adequately to take into account legal advice indicating that the policy of replacing the membership of statutory boards with every new administration may be unconstitutional. The Attorney General never told us that it is unconstitutional. Again, and I go back into it because you're talking about a very young government that's coming in, that's relying on the advice, a yes or no from the Attorney General, and also the expertise of the public service to guide them. So if one thing that is the common thread through all of this is that with the response is that we're craving to get our new policy adjusted, and we're just asking for the guidance. This is the common thread through all the response.
Right. So again, well, that's helpful to know because hopefully it will shorten things as we go through, Premier. But is your point reiterating again? And we've gone from the, if you like, the greater policy now to looking at individual boards as we go through. But your point here is again that the attorney, you rely on the fact that you say that the Attorney General of the day did not advise you in terms that this policy was unlawful.
He did not unequivocally say that there was not an issue that is either lawful or not. There were certain things implied, and again, remember minutes, whether we want to admit or not, minutes won't capture everything. And as a person come to give evidence, I would have to bring the background of some of what was happening. The question continue all the time is, Attorney General, is it lawful or is it not lawful? And if it is, or action is unlawful, how do we go about it? And if it is lawful, well, we have no issue. But with due respect, I'm not a lawyer. So when I get an answer with the utmost respect to the legal profession stating, however, in exercising his discretion to revoke the appointment of the members of the board, Cabinet must comply with one essential requirement of the rule of law identified by law in Birmingham, namely that a discretion conferred by statutes on ministers and other public officials must be exercised reasonably, rationally, in good faith, and for the purpose for which the power was conferred, and without exceeding the limit of such powers. End of quote. And the concept of reasonableness is defined by its opposite, namely Winsbury unreasonableness. A decision is said law Diplock to be unreasonable, irrational, if it is so outrageous in its defiance of either logic or morals that no sensible person could arrive at a conclusion on proper application of his mind. End of quote. Mr. Roy, with due respect, I'm not a lawyer. All we are asking the Attorney General, is it lawful or is it not? I don't want to seem difficult, but that's all we're asking then, and I even ask it now. Now with more experience, with handle certain things differently, but experience teaches wisdom. But at that time, a young government, is it lawful or not? A simple yes or no.
I think we now understand that point, and so hopefully we can, as we go through the boards, take that point shortly. But the advice that the Attorney General's given from the sections of the papers that I've read out is that you have a discretion. You have to exercise that discretion reasonably, and therefore you have to give defensible reasons for your decision. And it comes down to this, doesn't it? That your position is that, and it takes us back to that first discussion, that looking at your policy, you say that that policy justified a decision in this case to revoke in greater part the membership of the corporation. Well, you start with the corporation now, but for us, it was a gamut policy across the board. So we didn't look at it as electricity corporation. We didn't look at it as BVI ports. It was just the overall policy we were looking at. And when it came to individual papers, it remained the same. Individual boats, it remained the same.
I'm sorry, Graham. But you accept in the answer on page 2 that we're looking at, the legal advice was couched in equivocal terms, you've emphasised that, and referred to a risk of conflict with the Constitution. So you accepted that you were advised that the policy may be unconstitutional.
Yes, that is stated, it may be unconstitutional. But then, Commissioner, you know the question. Is it unconstitutional or is it not?
But before you make decisions which may be unconstitutional, wouldn't you proceed with caution?
Of course, by asking the attorney, is it constitutional or is it not unconstitutional? Is either yes or no. If a police stops you and you're speeding, you were either speeding, which means you were over the limit that was allowed by law, or you weren't speeding. It can't be that I stop you there because you may have been speeding. You had to be either speeding or not. So the questions that we're asking as a young government coming in, with the advice you're giving us, we are more confused when we get the advice, because these case studies, lawyers rightfully use them all the time, but for us, not law persons, we now have to go and look up, we have to go and look with due respect, all due respect to the law Diplock and all of them for the cases that they're referring to see, well, what is the context behind of what they were saying? That's not what you have a lawyer for. Is either you're telling us now, is our action constitutional or unconstitutional? If a sitting government is told uncategorically that your actions is unconstitutional, then you increase the risk if you decide to move against that. But at least now we have a clear picture, and it will be something very difficult for governments to say that they weren't told. But there's no clear answer by the Attorney General here in his post for the paper. Nor when we went in speaking about it, and that was consistent throughout all the papers with all the boards, most of the boards.
So you were content, the cabinet was content to proceed with the course of action which the Attorney General advised may be contrary to the Constitution?
I cannot say that we were satisfied that it may be contravening the Constitution. We were satisfied because he did not tell us that it was contravening the Constitution.
So you would have only stopped if he said, for sure, this is contrary to the Constitution?
We would have stopped. Most likely we would have stopped. I don't think I'd get the votes. Even one of us wanted to move ahead.
But in fact, you made the decision there and then, because in each of these cases, that may not literally be true, but in the cases we've looked at so far, there's been a discussion, we've been through that in respect of one board, and you've made the decision.
Yes, there's only one board that's under me where it's going to come up, that there was some legal opinion given. And after a while, we adjusted accordingly. We'll come to that, which will be the climate change.
With respect, the Attorney General gave a legal opinion. His opinion was this may be unconstitutional.
May.
Yeah.
But you know, Commissioner, telling someone that the kettle may be hot does not mean that the kettle is hot. It's either the kettle is hot or the kettle is not. So when you have an attorney...
I'm sorry to interrupt, but on that analogy,
yeah.
It's like you then putting your hand on the kettle. You would proceed with caution because the kettle may be hot. Here, the policy may be contrary to the Constitution. That seems to me to be pretty important.
But as a lawyer, I know that you would see how to house on that point. But look at it from different lens. If you say something may, it means also that it may not. So, and respectfully, I'm not a lawyer, but that's how we view it as person, not a lawyer. I expect the lawyer to tell me, I can take it if they tell me you may win the case, because no one knows what happens when you go to court. But if something is constitutionally correct or not constitutionally within the Constitution, that's supposed to be clearly articulated to ministers. May or may not leaves any government anywhere in the world up to decide on their own.
Okay, that answer's clear. Thank you.
If you look at, again, going back to your response, one of the points that was made was that insufficient regard was given, or no regard was given, to Section 4B of the Electricity Ordinance. Now, Section 4B says, and it deals with the composition of the board, but it says that when members are appointed, and that the ordinance speaks of governor in council, that's cabinet now. What has to be taken into account is that members shall be appointed by the cabinet, having taken into account the desirability of such interests as are affected by the corporation's activities being represented. So that when cabinet appoints, that is a factor that it has to take into account. Now, you say that cabinet wasn't advised, and this is a revocation decision. Cabinet was not advised that this section was relevant to its consideration, and in any event, it was not relevant to the revocation of the appointments. But would you accept this, Premier, that a decision to revoke here the greater majority of a board has the effect of removing expertise and experience from that board, doesn't it?
I can't agree with that, and I'm going to explain to you very clearly what I said before. If you poll that, 50% may say yes and 50% may say no. There are those who have strong feelings that if you remove everyone off of a board, that you have moved the experience, you have removed the ability to roll over things to persons, and that has its place. But I also know that there's a flip side to this, where there's an institutional knowledge which is captured, as I said before, by the public service. I know, but what I'm saying here is that he asked me, so I have to explain. So I have to put this down on record. So the permanent secretary, being an ex officio member, would be the one, even if the members return, to put on the table for each person when they come to the meeting, or even before, to give them what the criteria are. The board members would not be the ones doing that. and also to let them to know this is what the board will be expected. This is what your roles will be as a board member. You know, informal dealings of the government in these boards matters over the 71-year history. They want those things formally written down. So even on the electricity board, although it says there with 4B of affairs of the electricity, you try to pick business people and rationally thinking people, but the full explanation or description of what's expected wasn't there, and that's what we have moved towards now and walking towards. So the answer is that the institutional knowledge lies in the public officers. So the records are there so that if all persons are new, they can get a full picture captured that this is what was taking place. These are the areas that electricity would want to concentrate on based on the government's policy. And this is how we're going about it, because a public officer would have the minutes. They would have all that is happening in the institutional knowledge that lie within the public service cannot be underestimated at all. So boards help to flesh those things out in terms of the policy, but which will come from the sitting government. But the board now will flesh those areas out and see how things go. May I add, Chair, because I am here giving evidence. A board's job, and I honestly believe this, and don't agree to any board that tries to override or run the establishment. Because if that's the case, then the government could revoke the statute and run it themselves. But the board's job is to act like a board in any business environment. Bring the situations to the board, and they are supposed to rely on the technical ability of the day-to-day operations of the institution to come and say, these are the technical areas. These are also what we are looking at financially or otherwise, and put all the situation in front of the board members. And then they're supposed to be able to be fit and proper to say, we will review it and make an independent decision in the best interest of the public and the corporation, etc. That's how I see that boards run in terms of even if you move everyone off a board. I would say in retrospect, we would agree to leave on a few more persons. But if you ask for me to explain this in terms of if you remove everyone, that's the end of the institutional knowledge, I cannot agree with that theoretically, because there's a continuum inside of the public service.
Yes, thank you.
Take you back though, Premier, to what we are actually discussing, which is a decision taken on the 25th of March 2019. And it's very important if I could ask you to do that. If you can assist, what I'm asking your assistance for is on the circumstances in which that decision was made, not how one might make it today or what future changes made, but just looking at the circumstances of that decision, because it's out of that the criticisms arise. Now, you've said that institutional knowledge is preserved by the fact that you have ex officio members. The ex officio members are appointed because of their position. So a permanent secretary will have to sit on the board if the statute prescribes it. The members, the ones that you revoked, are appointed having regard to the interests of the corporation. But you're saying that no loss of expertise arose because any new member would be able to read the minutes that were preserved by the ex officio members.
I'm saying that in any well-oiled machine of government, the ex officio is the linkage between any old board members or new, or any all new board members, or some new, some old, because they would have all the institutional knowledge of what took place. And they're the ones now to furnish it to the new members. Commissioner, let's say that you left one member on, which in this case, I think one member was left on. It would be unreasonable to ask that one member that continues to bring the rest of the board with new members up to speed, even if there was two members. That has to be the job of the institution, to bring the board members up to speed, to make them aware of any statutes or any act that they might not have been aware of, to make them aware of the position financially and otherwise of the institution, and to make them aware of all the policies and guidelines that runs the institution. That's not a job for a board member. That's the job for the institution. Now, when persons get that information and with also their expertise, they will be able now to make an informed decision as a new board member, or even some board members that were there before. Because sometimes board members that were there before never ask certain questions, and it is not until new board members come that they recognize that there were other things that was happening that, or they should have been looking into, because somebody new came and started to be a little more aggressive in asking questions and checking on certain things. So the bridge for institutional knowledge is the ex officio officer. Yes, having some persons hang on was good because they may be able to tell you, you know, I would keep an eye on this or I'll keep an eye on that. But it is not etched in stone that having new members will drop down any institution. It is wise to carry over some experience. I agree that in retrospect, 1 or 2 or 3 is good to do that. But in the time when we came into office, I maintained that we needed to re-energize these boards. We needed to re-energize the territory. I mean, we have some setbacks with COVID-19, but we had to diversify economy. So it cannot be looked outside of the context of that.
Well, let's move on to criticism 2, please, Premier. Again, that is something that appears in the cabinet letter, and the response is the same. Now, the response there is something, if we start at page 4, please. If I summarize the criticism, because it is a criticism that has been, it reappears elsewhere in relation to other boards, and it has been addressed in the same terms by other witnesses in their warning letters and by yourself and by cabinet. In short, it is that in terms of recruitment for new members of the Electricity Corporation, which was done on the 7th of November 2019, that's when appointments were made, that on the evidence available to the COI, there wasn't, and I summarise, for the reasons set out, an independent and transparent process. And so what's said is that the outcome was that there was the process did not select, or it did not identify and select the most suitable and qualified candidates for membership of that corporation. Now that's in essence that. We see at 4 your response. Now, as I said, it's the response of a number of other witnesses, but it's essentially that what you rely on is the use of the informal process, isn't it?
Yes, sir.
Now, I just want to make clear that in relation to all of these boards that, and this is Dr. O'Neill Morton's affidavits, but there is no evidence, certainly in relation to the corporation, of the process by which the appointments that led to the appointments on the 7th of November 2019. So what reliance is placed on is the generality of that informal process. This is how it works in the past. Do you accept that?
For the last 71 years of a history with Legislative Council, that is how it has been. Till lately, we have been shifting in a new direction.
Now, what you go on to, and this is at page 5, you go on to address a point that was made, that no conflict checks were made. We said the criticism is made is that the handbook, paragraph 6.8 in particular, was not followed. Now that at page 5, it says that there's no basis for the assertion that the steps contemplated in paragraph 6.8 of the Cabinet Handbook were ignored. Cabinets are asked at the time they're approached, candidates are asked at the time they're approached to sustain their willingness to serve, if they might have any conflict of interest, and officials are mindful of the need to avoid such conflicts. And essentially the point that's made in this answer is that you challenge any suggestion that there was no compliance. But in the absence of any evidence to show that what conflict checks were actually made and how this was assessed, how can you properly say that challenge the fact that there was no compliance?
Well, first of all, when you say conflict of interest in this scenario, what do you mean?
A conflict that might prevent someone from working on being a member of a board and acting in an open and independent manner.
Which would mean that they would own another electricity corporation?
Well, no. Secondly, the second one is that a process that, the other point is that a process that is designed to identify whether conflicts or potential conflicts might arise. Now that goes to a public perception. If, for example, a minister appoints someone who happens to be his or her brother, the public perception might be that that person has been appointed because of the family relationship. Right. And the public will only know about that once the appointment's done under your informal process. There may be very good reason why that person is the best man for the job, but it goes back to the fact that if you don't have an open and transparent process, public perception might tend to show otherwise. But your question begs this, doesn't it, Premier? If you can't even tell me what conflicts of interest are being identified, how can you say, as you do in your response, that they are asked if they might have any conflict of interest? What conflict of interest were you referring to?
Well, you asked me, so I was asking you which one you meant. I'm clear which one I know.
Can we divide this up? The initial question was based upon the premise that there are no records of conflicts of interest. And that, I think, is true. Nobody suggested that there are any records of conflicts of interest.
As far as we know, because the cabinet handbook talk about immediate family.
No, we'll come on to that. The first question is, are there any records of conflicts of interest? Answer,
the
no.
informal process would have only involved the CVs, and in terms of any other information that our persons would know in the office when they're doing their checks, whatever checks they do. But that process there is one of the areas that we're improving upon, but not outright.
I understand that things may have changed,
right?
But I think the answer to the question is no. There are no records of conflict of interest, and I think the other part of your answer reflects the other evidence that we've had, and that is the chances are that the people considering the possible nominee, the desk officer, the permanent secretary of the minister, the chances are that they would probably know of any conflict of interest, any relationship.
Because of the size of our society and the cultural background of how small we are.
Yes.
If someone puts their brother on it, or their wife, or their children, that's a clear conflict. Unless, as the attorney rightfully says, that there's a specific need in the country that person has to fulfill. So that would be one that would be flagged right away.
But in terms of the process, it seems to me that the evidence we've heard from other witnesses, your evidence is the same. There is no records of conflict, but the chances are that one of the people involved in the process would know of any conflict in terms of relations and so on.
Commissioner, that's correct, because of our size, most persons will know.
I understand that. Yes, Mr. Rao.
It won't work in a bigger country, and we have to evolve from, but that is the answer.
Yes.
If we move on into the next point that's made in your response at page 5, which is a point that I canvassed with the Honourable Malone. You say it's always lain within the responsibility and power of the governor to instigate a change in the standard practice of public officers and the advice given to ministers on this subject. And you then continue to say that your appointed cabinet was not, at the time of these decisions, March, April 2019, advised, although the decision that we're concerned with is actually 7th of November 2019, you were not and had not been advised by the Attorney General, the Governor or the Deputy Governor that a particular system should have been pursued. So, for example, that there should be interviews or appointments should be advertised. So just to understand that your position and the position of Cabinet is that it lies, or it is within the responsibility and power of the Governor to set out what procedures should be followed in terms of recruitment to individual statutory boards.
I'm sorry to break in. Just to make sure that the question is a fair one. What this says is that the newly appointed cabinet was not advised by the attorney or the governor or the deputy governor. So this suggests that I think they're your words, but this appears to say that the attorney or the governor or the deputy governor could have advised in respect of a particular process.
Commissioner, that's well said. That's exactly what I meant.
Yes.
But it's just to clarify on the first part of that answer, which is that it's within the responsibility and power of the governor to instigate a change in the standard practice of public officers. So there seems to be two elements to the answer. Firstly, the advice element, and then secondly, the responsibly in power element. So I just want to understand what you say the sort of ambit of the governor's responsibly in power is. The governor could come in and say to public officers, in relation to this statutory board, there has to be advertisements, there has to be an interview process, it has to be done in this way. These are the criteria that must be followed.
In conjunction with the public officers and the government of the day from years ago, not just now. This is something should have been taken care of from years ago, not passing any blame, but I'm just saying it was a lot. We were evolving and certain procedures and processes didn't evolve as yet. And I would say that in this, when the election is held anywhere in the world, whether the UK or in the BVI or in anywhere in the world, it is up to the sitting governor or whoever is over the public service to prepare handover notes. Because you could end up, just like what we were saying with boards, you could end up with totally new persons in government that were never there before. The guiding light for them is going to be the handover notes. The guiding light for them is going to be brought up to speed with whatever policy, whatever laws, whatever was being worked on. Because no matter what government goes in there with whatever policy that they want, no matter what programs they want, there are certain international obligations or certain obligations that government would have had that's a continuum that they cannot break. So they would have to be advised accordingly. So the same would have to be for boards. Now I see that as a function that we all going to participate in now. We have had cooperation now with the deputy governor on this moving forward and the governor with that in the transformation, because we are on one accord that this was going to be done. But this could have been something that we had come to agreement with with the last governor. But it's only in May 2020 is when he started to raise concerns, and it was a young government that could have been brought up from 2019, and let's work together to get it done. But now that is the road that we're on.
Let's go back to the start of your answer. What we should add to the text, where you say it has always lain within the responsibility and power of the governor to instigate a change in the standard practice of public officers and the advice given to ministers on this subject. We need to add the words, it has always lain within the responsibility and power of the governor in conjunction with public officers and the ministers of the day to instigate a change in the standard practice of public officers and the advice given to ministers on this subject.
I wouldn't know if it's in conjunction, because under the Constitution, the governor is in charge of the public service.
The reason...
I'm sorry to interrupt, Mr. Wright. I just want to get this clear in my mind. In this paragraph, and as I say, these are your words,
yes,
although they're reflected in identical words by other ministers and public officials. But in this paragraph, it says, it's always lain within the responsibility and power of the governor. And then it goes on to instigate a change in the standard practice of public officers. Well, that concerns how what we would call the civil service, your public officials, are run as a body. That doesn't include the appointment by ministers of statutory board members, it seems to me. But you then go on, and the advice given to ministers on this subject. So am I right in thinking that this means that the governor could have advised ministers, could have told ministers the process to adopt, but he could have advised them as to the process to adopt? Is that the correct?
Yes, could
reading of your
advise
words?
ministers and also could have hold seminars to help guide.
Yes, but
the
so it
public
could have
officers.
been advice and training, all that sort of stuff.
Exactly.
But what the governor couldn't do, as I understand it, but correct me if I'm wrong, he couldn't mandate the process.
No, he couldn't mandate the process to.
Because that's the matter for the ministers.
That
The
would be a
minister-
matter for the ministers.
Yes.
Once they were guiding
No, so-
to do that.
Yeah.
But Chair, I just want to bring some context to our text again. When you come in and you're elected, and this is why we are working to make sure that in the future that this doesn't be a problem for anybody who's elected again. We are evolving community, and a lot of things were not written. So we relied on the institutional knowledge of those that were there before and that what was on the file, which not that it was wrong in depending on which lens you look through it. But now we're recognizing that you can't just ask someone to serve on a board. You have to have the criteria written down and approved criteria that this is what each board member and the chair would be doing. So that is the paradigm shift that government is now making, so that these concerns will not be so. Again, also may I add, that's why we're working now with the cabinet office to include the ethics section, the conflict of a thing, because that's important. A minister is so busy on a given day that to ask him to keep an eye on all these things would be quite unfair to any minister, whether it's this government or who. But having the institutions in place to make sure that is done is what we as a people are now working on, so that we could make sure that we avoid any perception of a negativity that may be arising how things were done before, because this is now on trial our whole culture over the last 71 years. So we are making the adjustments. So I just want to point that out as clarity.
Thank you. Yes, Mr. Rowell.
Just for clarity, and the reason I used the word in conjunction, Premier, is because that was your first answer to me when I put this to you.
Mm-hmm.
And so that sentence that begins, "it's always laying within the responsibility," is the responsibility and power to the governor alone, or is it responsibility and power that incorporates public officers and the ministers of the day? Because that's what you said earlier.
I would say, I said that based on a constitutional way, but it will have to incorporate everyone to allow the partnership to work.
So the governor in taking these steps would have to involve public officers and the ministers of the day.
For sure, you're correct.
If we move on to criticism 3, which is at your page 6, now that relates to what happened in the next stage to the corporation. So having revoked on the 29th of April was, I think, a number of members. There was one person left who then, Mr. Skelton, who then sadly died. And then there was a process put forward so that on the 18th of May, Violet Castro was recommended to Cabinet and then appointed on the 3rd of June, effective from the 25th of May.
Right.
And that was to take over Mr. Skelton's role on the Cabinet.
Right.
Now, the same criticism was made in relation to that process of appointment. And I think what you simply did was to rely on the earlier answer that had been given, which we've just discussed. Is that right?
Except for the first part.
Yes. Well, I think may relate to criticism 4. If you look at the response.
Yes, criticism 4 that.
Criticism 4 proceeded on the basis that you had a family relationship with Ms. Violet Castro, but you've said that there is no such family relationship.
Right, because the criticism said that Violet Castro was my aunt.
Yep.
And that I put her on knowing that she was my aunt, but that was not so.
Well, I think what it is strictly said was that you had a family relationship and you failed to declare it. Not that you appointed it, but you failed to declare a potential conflict of interest.
Criticism 4?
Yes.
It said, if I may, it says it is understood that Ms. Violet de Castro is your aunt.
Yes.
One, in proposing Ms. Violet and in her subsequent appointment to BVI Electricity Corporation, you failed formally to declare your association with her and failed formally to bring to the attention of the Cabinet a potential conflict of interest. So if I make clear myself, one, she's not my aunt. And two, the question would have been couple-fold if she was my aunt. The first, and this shows that mistakes can be made, but that doesn't question anyone's integrity. That's just an honest mistake, having violated the Castro in a public document as my aunt. Now, what we are looking at is the declaration of it. The cabinet handbook, if I may, because this is coming up for question and possible criticism. I was a young minister in 2007, that when we were in government, and that was the time when the Constitution came into being. I happened to hobble my way in because I was shot in a bank robbery. So I actually hobbled my way in as a minister. And we were able to work with the then cabinet secretary to come up with a cabinet handbook. I was younger then, but I was involved in the cabinet handbook's makeup. And when the cabinet handbook was done, one of the areas of concern or discussion was that what do we mean by immediate family? And what do we mean by close relative? Because it was a heavy discussion, most of the ministers now deceased, but it was a heavy discussion over what is the definition of these. Because we knew then what it is we are answering for now, that is such a small community based on our makeup and how the BVI has evolved from 1834 right up to now, where it was just one set of people that were landed here. We were concerned. So we, at that time, it was known that it would not stretch beyond your wife, your daughter, or your sisters, mother, father. That was my understanding back then. So coming into the government now and in years later, and hearing some of the definition, it definitely differs from that of the spirit of what that cabinet handbook had brought forward. Because we were part of the original cabinet handbook, and I was part of the then cabinet that passed the handbook. So I did not see, even if she was my aunt, based on my knowledge of being part of putting the handbook together and the discussions that ensued as a result, would have seen that, given how our culture is, as a big issue, because that doesn't mean that she's a close relative, although by blood she's your aunt. I know that it may sound different to someone coming through a different lens, but that was the thinking back then when we passed the handbook. But she was not my aunt. And also the issue was the normal course of action, Chair, Mr. Commissioner, is that persons would leave the room. But again, when we did the handbook in 2007, a question came up that is arising now. How does the Premier leave the room? Because under the Cabinet handbook and the Constitution, Cabinet needs a quorum to function. And not only does it need a quorum to function, one of the quorum of ministers must be the Premier. But it also needs compulsory to function the governor by post, the Attorney General by post, and the Premier. Even if you have a quorum and the Premier is not part of that quorum and the other two are there, you cannot proceed. So that again was a concern of, can the Premier by law, it's one of those anomalies inside the Constitution, leave? Because the only two times the Deputy Premier can act as Premier is if the Premier is sick or if he's out of the country. Those were very deep discussions in 2007, and I see them coming forward again now, where it was known then, well, all right, as once it's not your wife or children or your sisters or your father, your mother, or your mother-in-law, you would stay, or father-in-law. So those were precedents set from back then for me, that coming forward, that I brought forward. Now, if these are going to be interpreted differently, then again, we'll have to have some clear distinction on these, given how our nomenclature as a territory, because nearly everyone knows each other, nearly everyone is related. Sometimes we don't even know until the decision is finished that someone comes and tell you that's your family. That's how our culture is. So I just needed to put that piece of evidence inside there for as part of the evidence there with that, and just to confirm that She was not my aunt, and the reason for all the other actions as stated.
The fact she wasn't your aunt ends this criticism, because that's the premise upon which it's based. But do you accept that somebody in the territory might perceive that there is a conflict of interest if a minister were to be fully involved in the appointment of an aunt or an uncle to one of these posts?
If you go to an aunt or uncle, yes, I would stretch it and say yes, because that was also part of the discussion. But the criticism, with due respect, Commissioner, ends here. But a public document went out that that's one of my criticism, that Valerie Castro is my aunt. So what I'm saying is that certain perception when they hit the public are revocable and irreplaceable, because persons who don't know this will only hear it now when I give evidence. But there are already persons in the public domain said I put my aunt there, you know, other reasons that they will state. So these things sometimes do some political damage. But we are here for the law. But legally, she's not my aunt, and I didn't see anything that was violated. What I do know is what I put there. She has a long, distinguished career in the public service, specializing in accounting and administration, and is eminently qualified to fulfill the role to which she was appointed. She worked hard in not only this government, she was retired already, but in the last government and other governments, and is known for her professionalism.
Yes, thank you very much.
Just to be clear, Premier, you've said that this is a public document. It isn't. It was the warning letter is sent to you with there's a section at the end which explains the confidentiality of the process.
Right.
So your written response doesn't become part of the public record until we go through it.
Exactly.
And in fairness to you, the reason for going through it was because you made clear in your response that there is no family relationship. Right. And so that's why we've done that. If we move on to the next page 7.
But if
please.
I may, it's not a public document in terms of this paper out. But remember, there were only sections of it that you read, and you didn't read the aunt part. But the other parts that may seem in a controversial light were read, but that part was not an accurate bit of information that was given out that I needed to say publicly. So now it's out public. So I just had to explain why I had to say, because it was part of the criticism that was potential criticism that was laid on me. So I just need to make that clear for the record.
You have done so, Premier.
Thank you so much.
The reason I'm trying to take things shortly is firstly because the entirety of the written response will be considered by the Commissioner.
Okay.
And what I want to do is where I can and where with your assistance is add some detail to some of that written response. But also because we appreciate how busy you are, but we do need to get through this.
No problem.
If you go please to page 7, please.
Page 7.
Yes.
I'm right here.
So now we're on to the criticisms that arise in relation to the BVI Tourist Board. Now we've looked at the background to this already. And so if I deal with it this way, criticisms that are made to you in relation to the board, the first one is also one that is made to Cabinet, and the response is the same. So I'll just deal with both through you. That criticism, and we've looked at all of this because we went, the paper that it's based on is that memorandum that we were looking at from the 27th of March. And we've looked at the decision. Now, what you've set out there, and I think we've, Commissioner, unless you tell me otherwise, I think we have canvassed this in detail with the Premier, and he set out his response there. But when we went through the memorandum itself, the Premier gave an explanation as to what the or his view of what the Attorney General did advise, and his concerns over that advice.
I mean, this is Cabinet Memo 103/2019, which we've been through, Premier. The criticisms, which are sort of at the bottom of page 7, there are 4 of them, and I think we've dealt with all of them. That is the reasons for the immediate revocation of the membership of the Tourist Board, and the advice of the Attorney General. We've certainly been through that. The revocation of membership failed to provide adequately for the independent expertise and oversight of the board. You've dealt with that in your evidence. The policy of revoking the membership of boards with every new administration again fails adequately to provide for independent expertise and oversight of such boards. Again, I think you've dealt with that. And the decision to replace all of the board members failed to take into account properly the legal advice. Now, we've certainly dealt with those. Is there anything that you want to add to that? We've got your written response, which is in, right. I say standard form, I don't mean that pejoratively, but in the consistent form and consistent with your evidence.
No, I will join Attorney Rad and Silas. We could speed along with that one because the answer will be the same. So yes, we could speed along.
No, I assume that the answers to the same questions in relation to different boards will be consistent, Premier. Okay.
That's helpful, Premier. If we look now at criticism 2 under the BVI Tourist Board, and if you first of all look at the response that you gave, can I, before we do that, Commissioner, for your note, if you go down to page 9, you'll see that there's reference there to Bevis Sylvester.
Yes.
That is a typographical error introduced into the written response. It doesn't appear actually in the warning letter. And so I think from the words at the beginning you have stated to the end of that just needs to be struck through.
You mean when the criticism said that you have stated evidence?
Yes, because that is actually a different criticism, which I'll come up to in a moment.
Yeah, that one was given. That was given under the BVI Tourist Board.
Yeah, but it's been typed out twice by someone.
No, you mean that'll be typed by you?
No, it isn't,
Who?
because it doesn't appear in the warning letter.
So what do you mean in terms of typing out?
I mean,
twice. Oh yeah,
I'll explain it, Premier, when we get to it.
Yes.
But can we deal with this one quickly again? Yeah. Because this one is about.
On page 7 now?
We're on page 9.
9, okay. All right.
Premier. This now, what happens is obviously in March 2019, you revoke, or Cabinet revokes, the membership of the BVI Tourist Board. What then happens is that on the 26th of July 2019, a new board is appointed. And the points set out at criticism 2 are the same points in board terms as were, and this is about the process that was applied. Again, we have no evidence of this particular process, but what you have said is references made to the Premier's earlier response. So that we've canvassed already. We need to just, mostly for the Commissioner's note, look at the Cabinet letter and page 9 of the Cabinet letter.
So which page?
Page 9 of the Cabinet letter.
Right, sorry, yes.
We see the criticism set out again there, but there is a different answer in that. If we go to page 10, that's where we see references made to the Attorney General's earlier responses, and right at the beginning when the Premier started giving his evidence, that's the evidence that we canvassed with him at that point.
We've done that, yes.
So we don't need to deal that. Let's go back to your letter, please, and what should be, again, it's a typo at page 10, it should be criticism 3.
You mean it says to continue?
The one that refers to Mr. Sylvester. So
that's page 10.
Yes. Do you have it, Premier?
Yes, sir.
So this is a criticism that rises in response to you alone rather than cabinet. And it's, again, it's a conflict of interest one. So the point is made that you referred to Mr. Sylvester when you gave evidence on the 18th of May, 2021, that Mr. Sylvester, you described him as a good friend. And therefore, what's put to you as a potential criticism is, again, there is a failure to declare a potential conflict of interest, given that you are appointing an individual to a board that is under your portfolio. So it's the same, in the same terms as we looked at before. And your response is that there has been a misunderstanding of your use of the phrase good friend, that you are using that in the same way as everyone is my good friend. So you're described as a leading politician and that you would see everyone as your good friend. But what is said is that you were not indicating that you had any special relationship with Mr. Sylvester that would give rise to an obligation to declare an association with him. So just so that we're clear for the record, Premier, and you set out, summarize it, but you set out some additional detail. One is that when you were an assistant principal, Mr. Sylvester was a pupil at school, but you did not teach him. Two is that his family are well known and respected in the community, and you have attended his father's funeral, but also the leader of the opposition did the same thing. Three, that you only very infrequently meet Mr. Sylvester, which is invariably at public functions. And then you point to the fact that he has established himself as a regional manager for Delta Petroleum over many years. And so that has brought him a certain reputation. And then you point out finally that the Cabinet Handbook does not mention friends as a sort of relationship that would give rise to an obligation to declare a conflict. So again, just so that we bring it within that context, what you are not then is you don't have a close personal association with Mr. Sylvester.
Well, Mr. Rudd, I thank you for that long prelude before we got to the end pad, because I would understand that the public would understand what all of that was for. But let me be very clear. The last time that I was here, Commissioner, you would remember, I said that everyone I refer to as my good friend. If I even write in a letter or put in a text, I always tell them my good friend. So this has been taken so far out of context that it's difficult for me to even elaborate on it, because I do not live a life having enemies. If they want to hold me as one, that's up to them. I consider everyone as my good friend. I stated that when I sat here, and if the records of the COI would bear me out, it would show that I stated that when I came here the last time, that I said everyone is my good friend. I even started by saying in the earlies, before I even was asked, Mr. Rudd, my good friend, how are you? I remember that.
But that's what your response is.
Yes, but that's what my response is. But what I'm saying is that it was one of the, what you call it again, the potential criticism that was put in the paper to take out of context what I said and just attach it to BVI Sylvester. And I was wondering why it was attached to him and not anybody else, because anyone else on that could have been my good friend also, and they are. And it goes back to state that was taken out of context. I do not know how it was there. I know outside the legal realm how it got there and what the attempt is. But at the same time, too, he has no other special place in my heart for him on the board as my good friend, and any other one of them that's there as my good friend. It is something that I use wherever I go. I never thought that I had to be legally coming to sit down to explain that, but that is something culturally that I do. But I will say this too. That goes back to what I said earlier. Mr. Sylvester is the name that is being used, but we could have also used Ms. Kanisha Sproul. She is the chairperson of the Tourist Board, and she's also, because of that, on the Airports Authority Board, and also on the Ports Board. And I could have used the chairman of the BVI Ports Authority, who is now on the Airports Board and also on the Ports Board, because that is the triangle that I was talking about. So it was not a matter of Mr. BVI Sylvester going on these boards for any good friend of close relationship. has been purported here and in many other quarters, because today I come speak truth to power and the power in the truth. The Lord above in heaven know that the reason that they were on these different boards was because of our policy that I was explaining.
No, I understand that. Yes, thank you.
Premier, the point needs making again. The warning letter is not a public document.
No, but you read a whole paragraph of BVI Sylvester. I'm in this thing 22 years, Mr. Rod. I understand what you did.
What I read.
So I had to give you the context, the text to the context.
You have indeed done that. What I read was actually a summary of your answer.
Right,
The point,
but that's not public neither.
No, but the point for putting potential criticisms to you is because they arise from the evidence. The potential criticisms, given that the Commission is investigating statutory boards, and one of the issues that has come up and evidence has been gathered is who was appointed to where. Now, in the context of that, on day 6, the 18th of May, you came along and you described Mr. Sylvester as a good friend. Now, you've put that into your context.
No, Mr. Red.
Let me finish my point and you can respond, Premier. The point about that is that all that does is give rise on the evidence to potential criticism, which has properly to be put to you in fairness and which you have properly been able to answer.
I thank you, Mr. Red, but I put out a person as a good friend and they didn't come up in the criticism.
Well,
so everyone is my good friend. So any name on any one of those could have come up. Why was it just Mr. BVI Sylvester? That is a question that I have to ask, but I know the answer. But at the same time, too, as we say, we have disposed of it. But I had to bring some context to the text that was raised. I just saying that, and please forgive my wife. That's why I didn't want to speak loud, you know. But guys, does be perceived wrong.
But you've responded to that potential criticism. And,
I thank you.
And
but
I understand the response.
Thank you.
Could you just help us though with, just to return to Mr. Sylvester, and again, it's important to give it context. So you've said he's not someone you hold close in your heart. But you've also never been involved in any kind of commercial transaction with Mr. Sylvester at all.
In terms of finalizing transactions?
No, in terms of any kind of business, any kind of activity of any sort with Mr. Sylvester. Your position is he's someone you just have always met infrequently at public functions.
Mr. Sylvester's relationship and mine is no different than most of the person in the country. He's a good friend, and all of them are my good friend. I maintain that. I'm not going to run from all of them are good friends in the context of what I mean in our culture.
I appreciate your evidence is that everyone who gets appointed to every board or indeed removed from it under your administration remains your good friend.
With God's help.
But just to clarify in relation to Mr. Sylvester, so we're totally clear, you said there's no personal association, but there's never at any point, you've never had any other kind of involvement with Mr. Sylvester at any point in the past at all.
Well, I would never answer that outright like that because of this. This country, you never know what all you had with anyone else because it's small. So I don't want to say yes or no. And if you said yes, then you come back and tell me, well, what about this or no? Right now, I don't recall. So I do not want to answer that outright, whether it was Sylvester, whether it was Lady Cash, or whether it was anybody. I don't believe in tying up myself like that. I'll have to make sure. Because it's a very small community, you're in politics for 22 years, you never know. And I don't want to entrap myself like that.
If you turn up, part 2, please, to 1273. So I think the bundle we've been looking at mostly is part 3. I'd keep part 3 open, just on the table. Just grab part 2 quickly.
1273.
Yes, please. If you 1273 Premier, if you're there, is a page from a table prepared by Dr. Carolyn O'Neill Morton, and it is sets out the composition and of the various boards under the Premier's office portfolio and the change in composition over the past few years. Now, one of those who is identified as on the BVI Tourist Board in the past and it's and who had his appointment revoked on the 5th of April 2019 is a Mr. Mike Rowe. Now, when one looks at the actual decision, Mr. Rowe, and that's at part 3, page 293, 37 and 38. Mr. Rowe doesn't appear in the list of people who were revoked. And we can find no other record suggesting that he was revoked at the time. To your recollection, was Mr. Rowe a member of the BVI Tourist Board?
I only know that seen it here because our policy was blanket. So when the paper was prepared, I wasn't really involved in that part. I want to know who all. I didn't even get involved in that until afterward. So I can't tell you that I knew before. But whoever was on it was just a blanket of how we were going to reconstitute.
Well, I won't take that any further. Commissioner, if I could just explain that when Dr. O'Neill Morton attended on Thursday, during the course of her evidence, there were potential discrepancies identified in these schedules, and there's schedules in both of her affidavits. Dr. O'Neill Morton has provided amended schedules, but those still contain errors. This is one that I hope the Premier might be able to clarify. I won't explore the others with him, but I think it's something we might need to go back to Dr. O'Neill Morton about.
Okay, thank you.
Premier, let's move on to another board. And this is now the Airports Authority, which is at your page 12. Again, if I can just have a moment, Commissioner. Now, the first criticism is one, Premier, that was also put to Cabinet, and the response there is the same in your written response as well as in Cabinet, and it goes to the circumstances in which there were reappointments to the Airports Board. So what happened was that the previous board had 8 members and they all resigned. And Dr. O'Neill Morton explained that. And the potential criticism that's made, which is one that has been set out before, is again to the process. Again, we have no evidence, but the appointments were made on the 23rd of May 2019. We have no evidence as to the specifics of that process. But and what's pointed out again is that, as we've said, for various reasons, a failure to have a process that identified the most suitable and qualified candidates. And your response, we see at the bottom of page 12, and Cabinet's response is to rely on the earlier responses that we've gone through.
Yes, sir.
Thank you. If you go to 13, criticism 2, which is also made to Cabinet, and which gets the same answer as you give, is the appointment of Nathaniel Isaac. Now, Mr. Isaac had been appointed, as we'll see, to the Ports Authority. And as you've explained, there was a decision that what should happen is that there should be cross-representation of the Airports Authority, the Tourist Board, and the Ports Authority on different boards. And so Mr. Isaac appeared to sorry, give me a moment, please. What's said is that it appears from the evidence that Mr. Isaac was appointed to the Airports Board retroactively, and the fact that pending that appointment he was acting as a board member was and therefore making decisions without being properly appointed was inconsistent with good governance. And you've said that there was an oversight that meant he was left off the list of recommended candidates, but his status was well known to the board, and there's no evidence that he voted or exerted influence inappropriately over the board. And then his appointment was made on the 7th of January 2021. Could I just ask you to just assist, though, with some of the details around Mr. Isaac's appointment to the board? If you go to 3064.
Could you state the number again, please?
3064.
E064, in which one?
In part 3, please. You can put part 2 away, Premier.
Okay.
This is an email. If we look at the bottom, it's an email from dated the 6th of May 2019 from your then permanent secretary to Mr. Isaac, and it informs him that the Honourable Premier has nominated him to be a member of the BVI Ports Authority Board, sets out its function, provides a copy of the Act, and then at the bottom says, please indicate your acceptance of this invitation to serve as chairman of the BVI Ports Authority Board and provide us with a copy of your resume so we can complete the approval process. What it doesn't say is, can you tell us if there's any conflict of interest that may prevent you serving on the board? But what we see nonetheless at the top, and the date at the top is the 8th of May 2019, is that Mr. Isaac then responds and he provides he confirms that he's essentially happy to serve and provides his resume. If you go over to 3066, please, Premier. You see there that in terms of background, and we see it as a summary, the professional summary is that Mr. Isaac is a successful professional in landscaping and pool maintenance with over 30 years experience. He has a strong background in agriculture as an arborist, gardening, landscaping and pool maintenance, especially in the area of quality control and standards, research and training. If you go to 2794 in the same bundle, please.
So what number, Mr.
2794, please.
Thank you.
This is a minute from a cabinet meeting on the 15th of May 2019. And if you go to 2801, you'll see that at the bottom, that's the decision. We see the decision of Cabinet is to appoint Mr. Isaac as chairman for a period of 3 years, effective from the 16th of May 2019. So his appointment would take him through to 2022. If you go, please, to 3082. This is again a minute from a cabinet meeting on the 6th of May 2020. If you go to 3084, you'll see that in relation to a memorandum brought to Cabinet by yourself, Cabinet accepted the resignation of Mr. Isaac as chairman of the Ports Authority, and then decided to appoint Mr. Kelvin Hodge as the new chairman for a period of 3 years with effect from the 13th of May 2020. Now, we know that Mr. Hodge, and I can take you to the page if you need it, was already a member of the Airports Board. If you go to 3004, 3004, please. This is a Cabinet extract. It's dated the 13th of May 2021, but it confirms, as we can see, that by reference to the expedited extract and the date that it went to Cabinet, that on the 7th of January, Cabinet approved the membership of Mr. Isaac as a board member to the BVI Airports Authority Board with effect from the 1st of July 2020 for a period of 2 years. It was backdated by a number of months. Now, the 2 points that arise, and I take you back to your response at page 13, is firstly that there was never any real proper appointment of Mr. Isaac to the Airports Board, at least until the 7th of January. And second, if we look at your response, the basis of the response was that the need for Mr. Isaac to be on the Airports Board was that he was chairman of the Ports Authority. But when you came to regularize his status, he was no longer the chair. Kelvin Hodge was the chair, and he was already on the Airports Board. So what was the need to allow Mr. Isaac to continue on the Airports Authority in circumstances where he was no longer on the Ports Authority?
Thank you so much, Mr. Rowan. The question would be, with due respect, what was the reason not? Because he would have been serving on the Airports Board, or should have been, because he was the head of the ports. So there were some anomalies that were recognized. So the makeup of the board would have remained the same. Just mean another person from the board would have been that's already on the Airports Board wouldn't have had to be added because they were already on the BVI Ports Authority. That they were already on the airports, so they would now be the head of the BVI Ports Authority. So it was an anomaly that was recognized by the technical persons and by the board that it had needed to be regularized. So that is something not coming from me alone. It was something that was brought to our attention. So that's how I remember that, know that you're stating that. So that was regularized.
Your response gives the justification was that the need, the impetus was to ensure that chairmen of the various boards sat as members of each other's boards.
Right, so he should have been on the board from on the onset. But remember, not his position, because I also said earlier in my testimony that we couldn't put them on by post. They were on by person, because the Attorney General said that we would have had to change laws and different things to put them on by position. So he was never on the other boards by post, although it was an understanding until we got the amendments to the Act and different things done. So they were all on, knowing that they're the chairman, yes, and that they're on the other boards, but by law we couldn't put a post on none of them saying chairman of the BVI Airports.
I absolutely understand that,
Yeah.
Premier. But on the 7th of January 2021, when Mr. Isaac was appointed to the Airports Authority, his appointment was made on the basis that he was chairman of the Port Authority, but he wasn't.
No, that there when he went on, but he was there from before. There was an anomaly that happened that I would have to source the records. I remember there was an anomaly that happened because he should have been there from the original appointment of everything.
Fine. So he was accidentally not appointed.
Exactly.
But when he was appointed, why was he appointed?
As a member.
But
there was an error somewhere there that I don't want to misquote from it, but I know that there was an error because it was an anomaly that we were regularizing.
But when you were regularizing it on the 7th of January 2021,
right?
That's when he was appointed.
Right.
At that point, he was not the chairman of the Port Authority.
He had resigned suddenly. Yes.
So that wasn't the reason, because that was a policy that there was this crossover.
Right.
What was the reason?
As a member, has to be as a member now.
But why? Why was he?
It would have made the constitution of the number of persons completed.
So I understand, but why was he appointed on the 7th of January? What were the reasons for his appointment?
There's something that we need to get out of the ministry because there was a irregularity with him not being officially appointed through cabinet prior. There was an irregularity that I know that the files can bear it out. I don't remember it offhand, but I know that.
Well, that's included in your answer.
I know.
But yeah. on the 7th of January, I'm still struggling to know why he was appointed. He wasn't appointed as the Port Authority chairman. So why was he appointed?
Because he would have already helped to make up the composition of the board. Whether he was there, well, he couldn't be there by post because it wasn't a legal term. It was just something as an understanding. So as a person, he would have been the next person on the board.
So, but he was sitting with the board when they met, under the mistaken understanding that he was a member.
Right.
But he wasn't a member. So when it came to his appointment, what were you I don't understand what you were regularizing.
No, he was sitting on the board. From the board was formed originally, as you could see on the date, when the board originally formed. So that would have fallen along the lines of at that time when he should have been the chairman of one board on the others.
Understand that?
That is clear.
So if he had been appointed on the 23rd of May 2019, fully understand that.
Right.
But he wasn't.
But he wasn't appointed at that time. So when the time came now, this was already in train for it because the date he resigned was what again? The date he resigned from the ports. There's a resignation that he resigned. The date is important. Find that in the bundle.
I think it's on 3084.
3084.
And that's the minutes of the 6th of May 2020.
Right. Well, it doesn't say the date, but there's.
Well, at the top of the note, which is on 3082, it's the 6th of May.
Right. So that was the 6th of May in
2020.
In 2020, and he got on there in 6th of May in 2020.
Yes.
Right. But the airport board was constituted before that.
Yes.
Right.
Without him.
Without him. So that was the anomaly that he resigned then. But knowing when he was chairman, whoever was chairman was told that you will be on the other boards. So he would have started to attend those board meetings. So it was be a matter of regularizing him because he was already attending those meetings, albeit under the auspices of chair. But that after he resigned, he would have lost that chair, but still he would have been part of the composition of the board. So it was a regularization.
Yeah. Thank you.
Commissioner, could I ask for a 5-minute break, because just for the stenographer?
Yes, certainly. Yes, certainly. Now, just as to where we've got to and where we're going, Mr. Albert, there's a little bit to do on the Airports Authority, but I think only one further criticism in respect of that. We've then got the Ports Authority, and
yes.
We've been over that to a large extent because I think it's in the same position as the Tourist Board, but there may be some other points there.
And then we've got Telecommunications Regulatory Commission, and then finally the Climate
Yes,
Change Trust Fund. So we do have quite a bit to go through, I'm afraid.
but we'll certainly try and get through it. Let's have a 5-minute break and then see how quickly we can move.
No, well.
Thank you for a minute. Good. Thank you, Premier. We've been discussing this with Ms. Peaty and indeed with you, Premier. We still have 3.5 boards, I think, to go.
Yes.
We have to finish off the Airports Authority and deal with 3 more boards. And what I propose to do, and Premier, you've kindly said that this is convenient for you, is we will finish off Airports Authority, we'll do the Telecommunications Regulatory Commission today, which should take about 3/4 of an hour, and then you've kindly agreed to come back on Thursday at 3 o'clock when we'll deal with the other boards. Thank you very much. Mr. Rowett.
Thank you, Commissioner. Premier, before we broke, we had looked at the second criticism which you've canvassed. Can I just ask you just to go to page 2961? Now, this is taking us back slightly to criticism 1, but it's a memo from the 6th of May 2019. It's actually said to be issued by the Ministry of Finance. I think that's an error because the Airports Authority sits under the Premier's office, doesn't it?
Yes.
And what you've got is you've got the appointment of new board members following the resignation of the entire Airports Authority board. And if you look at 2961, what's noted is a list of the proposed membership and the CVs received thus far of the BVI Airport Authority Board is attached. We are still awaiting CVs for Mr. Marlon Chikutu, Mr. Theodore Burke, and Mr. Raoul Sproul. However, they have orally accepted. So this paper at the back is then on 2963. Carries your name, the date, and we see at 2964, that's the cabinet decision. So it appears, Premier, and this takes us back to the use of the informal process, that in this instance at least, 3 individuals were appointed to the board without their CVs having been received, because we haven't been provided with those CVs. So there's no evidence that before the appointments were made, those CVs were received and considered. And I'm right in thinking this goes back to the point that these papers, when they go to Cabinet, can be amended by Cabinet, aren't they?
Yes, Cabinet does have the right to amend. Which 3 members may I ask?
If you look at 2961, please, we are still awaiting CVs. Do you see at the top?
Okay.
Let's then take, those 2
which ones? Marlon Chikutu, Theo Bork, and Raoul Sproul.
Yeah.
Okay.
Now, I mean, the point is a short one. They were appointed. It's on this paper and on the, without Cabinet having seen their CVs or the Ministry having received them. Now, on the BVI Airports Authority, if I take you back to the warning letter, the 3rd criticism is directed you as Premier, and it relates to declarations of interests again. And it's the potential criticism is in the same terms as we've seen already. Firstly, that there is an association with an individual. Secondly, that you failed to formally declare an association. And thirdly, you failed to seek legal advice as to the conflict arising. Now, in relation to one of those individuals, you've referred to responses earlier given, and in relation to the second, you say this, you explain the nature of the relationship, you explain the person involved is well known, and just to be clear, I mean, you gave evidence to this when you first came to give evidence, Commissioner. You confirmed that Patsy Lake was your first cousin. Mrs. Lake was one of the appointees to the Airports Authority, and you've given details of her background. But it begs a wider question, Premier, and one that you've touched upon in your evidence. if one looks at the evidence that has been canvassed with ministers as they've come at various points, you can point to examples where, for example, a minister has recused themselves because a sibling is being proposed for a position. There are situations where a mother-in-law is proposed and somebody recuses themselves. Now, your position is that, and it goes back, you make the point that the Cabinet Handbook does not specify what immediate family is or close relative is for the purpose of giving rise to an obligation to declare. And you've made the point in relation to Mr. Sylvester, it doesn't refer to good friend. But isn't it the case that there is no consistent approach at present on the part of any member of Cabinet as to when and when not to declare?
That would be a fair statement in that the terms of these have to be more defined, which is what we are working towards now, given that this is an evolving situation. And that is part of what our proposal was in terms of our statement on the that we made in terms of good governance, and adding in that layer inside of the cabinet office for the cabinet secretary. It's needed now that some of these things have come into question, and also the country is evolving more and more to safeguard all of us. So those are the areas that we're going towards, and even more safeguards inside of each ministry, because this has been a long-standing practice, as I said, for the 71-year history of the territory since we had, well, more than 71 now, since we have had legislative council. So it's not an action that we have done just like that. And as I stated in my response, even to the first cousin part, in this country, for example, I have over 75 first cousins. And not because you're a first cousin, it means that they are close relationship. I have at least 75 of them. Miss Lake, that's mentioned, is 25 years older than me, so I need to put it in context. I haven't grown up with her. We never went to the same nightclubs or the same friends, and we did not grow up together at all. We have a respectful relationship, not in the sense of being close personally, and she'll be considered extended family. And she is a national personality. In fairness to why would you appoint someone like that? She's a successful entrepreneur and businesswoman, and fought back the Wickham-Ski lands for the BVI people in the positive action movement with Noah Lloyd years before I was born. Because of these efforts, a lot of Virgin Islanders have landed on Wickham-Ski today. And she was a celebrant of the Emancipation Day in 2015. Was under the
coming administration sitting down and saying, these are the lines for us. If anyone feels that they are crossing a line, this is where a conflict could arise. I mean, there was nothing in to stop the five of you sitting down and drawing up a policy by which you would try and consistently identify conflicts of interest, was there?
Well, hindsight is always 50-50. I mean, 2020. And I said 50-50 for other reasons scientifically, but it's always 2020. At that time, we were trying to pass a budget, and it might not seem like much now because of what we had to go through. A time frame, it should have been passed by the end of the year. That's the legal time for the budget to be passed. So we were dealing with a lot of things at that time in terms of that and many other areas. And we also wanted to get a jump start in re-energizing the different boards. So we did not move into that direction at that time. And then we didn't even get to settle long in comes COVID. But even in the midst of all of that now, the evidence is there that is where we have now moved towards. That is before we have to come into a commission of inquiry. So we recognize that after a while that we have to further strengthen good governance in the territory. In many areas, we have moved not only in that data policy unit, within the Premier's office to also transform the public service, in which we're going through the public service transformation in agreement with the governor and record keeping to improve upon that. So all that we're working together in some of those areas with the governor, with the other ministers, with our government members. So we were a young government. The only person I was ever elected before was myself. And I was never Premier before and spent quite some years in opposition. So when you come into these offices, what we recognize now is to make sure that anyone that comes again doesn't face these things, that it is properly documented what all is expected, what all is needed, based on our modern day standards and also some international standards that we're now raising the bar even more towards. Not saying that what was done humbly, respectfully, was done in a bad faith. All of it was done, all other governments in good faith in the public interest. And if you research across all past governments, you see that the action was the same. So it was just the culture of how things were operating inside of the service. So now we are trying to put it to our next level. So the answer would be, in hindsight, it's easy to say that at that time it was not something that we fathomed to do, because we thought that with advice that we would have received from the Attorney General and others, that would be suffice. Because we have to recognize too that that's why we rely on Financial Secretary. We relied on all the technical persons, the AG and everybody at that time. That was so important for us, because if we didn't rely on them and also trying to read up as much as we could as a young government to make sure we push everything forward and diversify the economy. Commissioner, I was just rounding off by saying that I'm asked to give a yes or no answer at times, respectfully, because I know Mr. Wright is doing his job. But now the AG didn't give us a yes or no, and I go into that because it's your main answer. And I know at times you're getting frustrated when you see us, when you see me not giving you a yes or no. Well, maybe you can now understand what cabinet ministers felt when they asked the Attorney General for a yes or no. I get the impression that it seems the lack of yes or no answer is inadequate. But cabinet ministers had to accept an answer from the AG that lacks yes or no. And once you're in these leadership role, something that all leaders would know, you're as good as the aid that's assisting you, and also the handover notes that you meet. And if it is void of certain things, only your experience after a while would tell you that this needs to be improved upon. So, Mr. Rudd, Attorney Rudd, sorry, let me address you correctly, Attorney Rudd. That is my answer. Given our experience now, we recognize what needs to be done and it's working on.
So the answer to the question, which is yes, that there is an inconsistent approach to conflict of interest, and you're doing something about it. And I appreciate a lot's happened in the last 2.5 years. But when did you start to address this particular issue of conflicts of interest? When did you, are the papers now to address the issue about conflicts of interest and the degrees of relationship, or how conflicts of interest are to be defined?
Those are ongoing. Some of them are in the present legislation of the integrity in public life. It's already had its first reading in the House of Assembly, and next week it will have its second reading. So these are not just things that I'm saying. And once passed, I'll take care of quite a bit of those areas. I know also, I was trying to remember the date, but I know that in the 6th of April, 2021, which I would ask the office to get that information paper. It was a paper done on the new era of accountability and transparency, the information paper that I was talking about, that started to list out what we wanted to do with boards and how we wanted to move forward. So with that, and also what we were trying to do with the transformation of the public service, with what we were trying to do also with the Cabinet Office, and all of the legislations that have already been passed in many respects, quite a few of them, to further strengthen good governance, shows our commitment to help this evolution to get to the next level. while at the same time maintaining our economy to make sure that we strengthen our economy, diversify our economy, which is crucial.
But in terms of the policy paper, that was the 6th of April this year, the new area of transformation policy paper. Okay, thank you very much. Yes, Mr. Wright.
Returning to conflicts of interest, Premier, and your answer was rather more wide-ranging. You've referred in your response to the Cabinet Handbook at paragraphs 2.23 and 2.24, but it's important to also bear in mind 2.25, which, if you need to look it up, is at page 2769 in the bundle. 2.25 says ministers or members having doubts or uncertainty about their interest in a cabinet matter should inform the Premier in advance of the matter coming up for cabinet discussion. And so what that says is it sets a low threshold. So a minister having doubt about an interest, and it doesn't necessarily need to be a family interest, because 2.23 says if you attend meetings in relation to matters in which you have an interest, must declare their interest or members of their family interests whether private, pecuniary or non-pecuniary, of ministers, members of cabinets or their immediate family must be declared prior to discussions, and declarations of interest at 2.24 should be recorded. So it doesn't necessarily restrict as guidance ministers to declaring family interests or a family connection. They might have, for example, an interest in a business or a historical interest or an association with someone who is bidding for a contract. But ultimately, so the first point is that it appears to have been read narrowly to just refer to family interests. But ultimately, the person who should be in a position to advise ministers or members according to the handbook is the Premier. And if you have uncertainty, despite having served in a previous administration, and as you say, having been involved in the promulgation of this handbook, if you have uncertainty about what it means, what hope is there for the other ministers?
Plenty hope under these auspices. As we grow the Virgin Islands, it should not be on the Premier's shoulder to decide those things. That's where the ethics unit of the Cabinet Office comes in. That should not be up to any elected official to do, because the Premier now would only interpret, whoever the Premier is, not saying it's me, will interpret these to the best of his ability. If he's not a lawyer, it might not be interpreted in the way that Attorney Rat just interpreted it. There must be systems in place to handle these concerns. That is why in our position paper on good governance, we stating that this arm of the cabinet must come into force so that ministers have that layer of protection even from themselves on misinterpreting the law. So there's great hope because we are already moving in a direction to further strengthen good governance in this area.
But the question is directed to not the future, but what has been going on since March 2019. And aside from you as Premier, would you agree with this? And it comes from the Honourable Reimer's evidence on day 11. So I asked him about conflicts of interest, and he says when one arises, if he has a concern, he didn't, and I'm sure he meant no disrespect, he didn't mention the Premier. He said he would raise it with either the Cabinet Secretary or with the Attorney General. So there is already in place that recourse, isn't there, for advice?
Once you feel that there's a conflict of interest, or if you recognize a conflict of interest. But what I'm saying, it should not be up to any member's interpretation. It should be clear what is expected of you, not only conflict of interest, declaring of interest, and the whole gamut of it. And there should be a unit that is the litmus test to solve for that. And may I add, that's not happening since March 2019. This has been common practice over the years of it not being clear over the years of the history of the country. So we're now evolving to the point to get it fixed.
Okay, let's go to page 21, please, in the warning letter.
Page
21.
Oh. In this bundle?
No, Premier, in your warning letter.
Only one letter, okay. All right, I misunderstood. Thank you. Yes.
Now we should be at the Telecommunications Regulatory Commission. And there are, I think if I've counted correctly, 6 criticisms set out there. Criticisms 1 to 5 are also set out in the Cabinet letter, and the response in the Cabinet letter is in the same terms as your response. Criticism 6 we can deal with very quickly, and it relates to a potential conflict of interest, and you've dealt with that by referring to an earlier answer. So let's look at 1 to 5, please. Now, what was raised, and hopefully we can take it shortly. The potential criticisms, Premier, are advanced on the basis of the evidence that has been obtained by the COI. And in relation to potential criticism 1, that related to the appointment of Mr. Vance Lewis as a commissioner of the TRC and chairman for a period of 3 years with effect from 1st of February 2020, and Mr. Vincent Whatley as commissioner and deputy chairman of that commission, again for the same period. And the point is made that 2 points essentially about this criticism. Firstly, the failure to follow an open and transparent process, and the same points are made as have been made in relation to other recruitment schemes. And again, I stress we have no evidence of the process through which this was done. And secondly, the failure to obtain a statutory declaration from either person to show that they had complied with Section 7.5 of the Telecommunications Act 2006. And that section sets out various bases on which someone can be disqualified. Now, what's said is that both Mr. Lewis and Mr. Whatley made the necessary statutory declarations, and therefore their appointments were consistent with the Act. And a copy of Mr. Lewis's statutory declaration was enclosed. Now, that was the first that the Commission had seen that statutory declaration, so that deals with that point. As you will have heard the Commissioner say this morning, Mr. Whatley's statutory declaration was still outstanding. That has now, as I understand it, been provided. And so that deals with that point. The second criticism is that there's no evidence that's been produced to the COI to show that there has been a resolution tabled before the House as required by the Telecommunication Act dealing with these appointments. And the response was the resolution was laid before the House and approved on 27th February 2021. A copy of the Hansard record of the House of Assembly is being sought from the clerk and will be furnished to the inquiry. We can't take that any further with you today, Premier, because there is yet that point has still yet to be provided, that proof of that resolution. In terms of 3, it again takes us back to a point that we've just been discussing, which was in relation to this process. There's no evidence of conflict checks being carried out, and therefore the procedures of paragraph 6.8 of the Cabinet Handbook were not followed. And you respond back, references made to earlier responses, we've discussed those. You say that both Mr. Vance and Mr. Lewis were consulted about any possible conflicts of interest, and there's no basis for the assertion that there was no compliance with the Cabinet Handbook requirements for the submission of candidates for statutory boards appointments to the Cabinet. Now, did you have any requirements specifically in mind? in 6.8?
In terms of the conflicts,
Yes.
one of the things was to make sure that they're not involved in any of the telecommunications companies, and that would impede their judgment to be impartial when they're making decisions. So there was concern that we needed to make sure of that, because that's one of the key areas, because you have some decisions to make that definitely would influence how telecommunications would operate in the territory. So that was a key one that persons were looking for, to make sure that they or no one around them that's close enough had that kind of relationship. So that didn't pan out that way. I know we were waiting on the transcript you said from the clerk, but it did go to the House and there was a heavy debate on it.
Go to 2785, please, in part 3. What, if you look at 2784, what paragraph 6.5 of the Cabinet Handbook warns Cabinet members to do is to be mindful of approaching potential board members so as not to preempt the Cabinet decision. And it limits the kind of contact you can have. 2785 sets out 6.8, which is what's raised in the potential criticism. My question was whether there were any specific aspects of 6.8 that you had in mind for when responding that there's no basis for the assertion that there was no compliance with the Cabinet Handbook.
In terms of there was no, repeat that for me, please.
Well, what was set out to you in the potential criticism was that the procedures in paragraph 6.8 of the handbook were not followed. Your response was references made to earlier responses. Both were consulted about any possible conflicts of interest. There's no basis for the assertion that there was no compliance with the Cabinet Handbook requirements for the submission of candidates for statutory board appointments to the Cabinet. Now, I stress, Premier, that where you say both were consulted about any possible conflicts of interest, the COI hasn't been provided with any evidence of the extent of the consultation. But it's this bit, which bit of 6.8 do you rely on to say that the requirements were met?
Well, in terms of those areas, as I read them through, even back then, we tried to make sure that they fit the bill as much as possible, but that was not an exercise that I would have been doing. That was an exercise that the technical officers would have been doing to make sure that when they move forward, that these are met as close that could be met as possible. But again, if you look at us, and I must stress this, through the lens of a bigger country, the UK or what, you will come down on us in certain areas, but in our culture, it is different. So it's going to be tough to grade us on that, because then the informal process, which we recognize as we evolve more, has to continue to be strengthened in areas that would allow us to be able to say we advertise or whatever the case may be in other areas, but we cannot divulge what it is or we have been doing over the years. Not this government alone. This has been consistent. If you check all the files, even outside of government, we have an informal community. You hired someone, you sometimes you don't even have a contract. You just tell them, I need you to tile, and they come, they give you a price and you work. So we have an informal society because of our size, and I don't want this thrown out when it is being analyzed how we operate. Yes, are we evolving to be more what we will call formal in proceedings with a government or otherwise? The answer is yes. Have we made some strides? Yes. Do we have more to make? Yes. So we try to cover as many as we can, given what is written. But I want to stress that no matter how many times you ask me, though, Mr. Rudd, I'm going to still go back to Tony Rudd and state that it is a lot to ask a minister of any government at any time in any era to be the one to police in these areas. That is why we have to continue to strengthen the structures around us to make sure that they're done and done for the ministers, done for cabinet before time. That's why we were before just solely relying on the Attorney General's input so that they could flag any area that they saw that was not adhered to before we reached the cabinet. And so that's the best that I can answer that, because it's a lot to ask a minister or the post of premier. Not saying it have to be me to monitor all these things. It's quite a lot.
But the bottom line is, I think, subject to your correcting me, there are no records of conflict checks. There are no records of anyone meeting the requirements in paragraph 6.8.
Meeting the requirements, proposal for police recommendation committee members.
There's no record of any of this. That's an integral part of the informal process, that there are no records of anything.
Well, there are records of different things, but if you're talking about how boards or certain parts of government were operating, that would be a challenge if you weigh us in the balance of the scale of looking at us of how things are done in the UK. Sometimes it's done informally, Commissioner, in terms of, I know that you that you're very good in this area, and then after a while you'll be known to the community, and in an informal way it will get wrong, and you say, well, all right, this person has the skill based on what you know. Even if you look at the Commission of Inquiry as we have it here, no offense to anyone, I didn't read that advertisement for any other post, but because of your reputation before, I read Mr. Radilla other inquiries. He was selected based on his experience and then the knowledge of him, unless there's something else I don't know. But even here now it's even more informal than that, where we'll be selecting persons that you will know that this person is good in the business field, or they have carried their company. Like one of Mr. Borky has raised the family business to another level. So we go on the premise that we know each other and we see how persons have progressed in their life and then ask for their CV. So now the advertising and other areas that we evolve into will start to complement and also clean up those areas that needed scrubbing from around us in the past, but it's not that it was done in bad faith or done in a mindset of not being transparent and accountable. I just need to highlight that.
Let's move on a little bit, Premier. Just deal with criticism 4. Before we do, if we just give it some context, if you go to 3116. So that's the paper from your office going to Cabinet to appoint Mr. Lewis and Mr. Watley. And if you look at 3117, that notes that the TRC has been without a chairman since August 2019 and without a deputy chairman since the resignation of Mr. Ian Smith on the 16th of February 2016. And the point that is made is at criticism 4, that in effect that meant that there was no quorum, and so it was unable to perform its statutory function for approximately 6 months. To give some more detail, if we look at 3119, at 13, the Attorney General's point that was raised was that there was a need to establish that the 2 appointees are not disqualified, having regard to the provisions of Section 7.5 of the Telecommunications Act of 2006. And that's usually achieved by having the proposed nominees execute a statutory declaration to this effect. But the paper, the AG says, doesn't allude to the requirements of this provision having been satisfied at all. Now, the matter, if we go to 3122, paper went to Cabinet. We have the decision being made on the 5th of February 2020 to appoint Mr. Lewis and Mr. Watley. Now, as I explained, we had received a copy of Mr. Lewis's statutory declaration, and if you go to the very last page in the bundle, Premier, (3309), we have a declaration dated the 5th of February 2020. So the date on which Cabinet actually made the decision is the date of the statutory declaration. And just checking, as I indicated, Mr. Watley's declaration is actually dated the 6th of February 2020. Now, in terms of the TRC not having a quorum, what you say is appointment to the senior posts at the TRC require knowledge of the telecommunications industry. As is often the case with roles that warrant a level of technical or professional expertise, it was difficult to find suitable persons willing to take on the onerous responsibilities. Once individuals are found, there must be consultation with the leader of the opposition. And in addition, no advance succession planning had been undertaken in anticipation of the expiry of the former chairman's tenure on 12th of August 2019. So does it follow from that, Premier, that it was the search for commissioners really began in August 2019?
There was a search for commissioner for then, but you know, when it turned over into 2020, there was quite a story what we had to deal with. So there were things that didn't get dealt with as soon as we would have liked to in certain areas.
So, Premier, the reason for my question was just because your answer seemed to point to the fact that it's difficult when you're looking for, if you like, specialist knowledge. It's difficult to find people. And so it was just simply, did your search begin in August 2019 and it took you till February 2020 to find the right two people to put before Cabinet?
Not only difficult based on the knowledge, but also one of the key areas is to make sure that they're not involved in any of the telecommunications company. Given the small makeup of our territory, that's easier said than done. So we wanted to make sure.
So what you need is firstly people who have knowledge of the telecommunications industry, because it's a role, as you say, that warrants a level of technical or professional expertise, but also that they don't have an ongoing connection with a particular telecommunications provider.
Yes, and also in terms of making sure that they are as analytical minded as possible and business minded, because you do not need persons with only the skills on any board to be able to guide the board. Meaning that if it is the planning board, you only need architects. You always need some persons with different skill sets to balance, because different points of view helps. It doesn't, if you choose to major in architecture or telecommunication, I don't. It doesn't make me less intelligent than you. It just means that we majored in different things in the university. But when it comes to managing and also giving input, or input could very well be as valuable as a person who has the expertise in that technical area. So it helps to have one or two persons with that expertise, but it also is good to have a balance of persons, whether it be business, even some laymen, because our country was built on farmers, fishers, and even taxi operators, and many of them serving on these boards in the earlies, and they brought us to where we are. And then we continue to evolve and be able to have more personal qualifications, but we can't count out experience also, because it brings an added dimension to any board that helps significantly, because you know, in our dialect we say book sense without common sense is nonsense. So you need that balance.
The reason for the question, Premier, was that given that the response places such weight on knowledge of the telecommunications industry and roles that warrant a level of technical or professional expertise, why was it that you and Cabinet appointed 3 people, namely Mr. Watley, Mr. Bevis Sylvester and Ms. Jocelyn Moraine, who appear on their CVs not to have any knowledge of the telecommunications industry or the required level of technical or professional expertise?
Well, I just stated, it's not just for the technical areas. I didn't know you were going in that angle, but it's not just for the technical areas. When you look at someone like Ms. Joyce Marine, who has been one of our leading bank managers, I don't know her personally, I want to state that very clearly, but a good friend nevertheless. In terms of once you're living for me, you're my good friend, but brought the bank to a different level in the eyes of the public, and is known by many for her professionalism, her independent thinking, and not being able to be swayed by any political directorate, and go and upgrade all systems that she's worked on to another level. So those are things that are known throughout, and no different from Mr. Sylvester, who have created, improved Delta from just here in the Virgin Islands, one or two areas now to a leading, what do you call it, petroleum giant. And then you have Mr. Watley, who is known for knowing his knowledge in the field of telecom and electronics. So these are things known by any person who resides in the BVI over the years. It's not something that's not known. And so in terms of our processes that involve that informal sense, it still had some ethics in it, into making sure that you get persons who going to be progressive, who are going to be proactive, and who are also going to help us to move the board, not just with the technical knowledge, but also with the progressive mind, knowledge, and the energy to get us to get out of our telecom companies, although some will be listening, to get them to get us to the next level and get us consistent internet. And it has been a challenge, and also to collect any outstanding fees. And you needed persons that would not be contaminated by being in any relationship or in any business dealing with any of the telecom companies. And I would say that I will dare to say that the record has shown that if there were any concerns of the line of whether or not they would be functional, the record is showing that they are functional, and in the middle of renegotiating right now the new telecom licenses that are coming up that will give us a more stable internet. That is the next crucial to our next economies here in the Virgin Islands, a stable and faster internet. And they're working towards that. So their reputation, professional and progressive wise, speaks for itself.
Right, well, that's helpful because we can put your response to criticism 4 in the context of the answer that you've just given. Can I turn to criticism 5? Now that relates to a decision that was taken on 16th of February 2020 to appoint Ms. Jocelyn Moraine and Mr. Bevis Sylvester as commissioners. Now, what's set out as the criticisms, the earlier criticisms in terms of the nomination process, in terms of the need for a resolution, and in terms of conflicts, apply equally to these later appointments. And you have, as well as referring to Ms. Moraine's background, which you have also just done in oral evidence, rely on your earlier responses. I don't think, therefore, I need to go through that again. The only point to make, and to commissioners, just to update you, is that you obviously asked for assistance in terms of statutory declarations in relation to Ms. Moraine and Mr. Sylvester. I understand that they are not available.
And will not be available.
That appears to be the case. I'm looking to Ms. Peaty.
As far as I understand it, there are none on record.
Yes.
Would be in your hands if you want confirmation of, say, the search that's been undertaken or what have you, but as it's a nil return.
No, I'll simply accept that there aren't any.
Commissioner, I've, I think, reached a sensible point to
But
pause.
may I add something before we close that to bring clarity though? In terms of the, if I could just go back 1 minute, it's very important for the record. When I was trying to remember what happened with the situation with Mr. Isaac, and the reason that he was on the board before was that we were taking some time to get the paper done, but it was an understanding all the chairs would have been on the board. But under the act of the BVI Airports Authority, which you of course will check, it does allow them to appoint certain persons themselves because it's a corporate body, the BVI Airports Authority. So they went ahead and did that until the central government regularized the appointment. So I think that was important to point out for the record with the act. And the last part in terms of this TRC with the declaration, I don't know if it is being perceived that the declaration is the one that also goes to the House of Assembly. But I would say that from the time the Telecommunication Act has been in place, I have never seen or heard of the other members come into the House for declaration for debate. I've always known as being the chairman, and also persons will even speak about the deputy chairman. So again, we go into making sure that we get those entities in place in government to make sure that whatever it is lacking based on certain things written, that we do not miss those, but they're not being missed when they are intentionally. It just is a lot to consume for a public service that's in the public officers that are working hard to deal with so many matters. We are focusing on the areas that there may be some concerns of it. Is it following the law down to the T? But at the same time too, I must recognize their hard work and efforts, because it's a lot on a daily basis running the territory, but we do recognize the areas that we have to improve. And we are working on them, I might add, and it's clear.
Could I just ask one question before we finish, Premier? And I know it's going back, but I just want...
Before we pause.
Sorry?
Before we pause, because we're coming back, but I know it is.
And it's this, we went through, you went through in some detail about the policy to revoke the membership of statutory boards, and we've dealt with that. But there was another element of the policy, and that was to make the membership of statutory boards coterminous with the period of the administration.
At that time, yes.
Can you explain that? That just seems to emphasise that it's a political appointment, perhaps. But could you just explain the thinking behind that?
Well, thank you, Commissioner. I think with time I will be able to shift your mind on it being political, because even on the Airports Authority, if you look at the makeup of it with the members, there's one person named Hippolito Penn. He's on the membership. He actually ran against my deputy premier in our party. So if it was political for us, in terms of what is said here and in our quarters, he would not have made a cut. So we were looking for energetic, minded persons and to shake up the boards. No offense to who were there before. Some persons were placed back on some of the boards, and some persons on those boards were put on other boards because we thought that their strength would be better for that. For example, the chairman of the BVI Airports Authority, he was, he resigned, but with the same government put him now as a chairman of the BVI Immigration Board, and it was not anything a mindset of political. It was dealing with the public interest and how we could energize it.
I understand that. So the whole thrust of this was to ensure that the boards had energized people that were committed to your policy program. I understand that. But if that's right, why bring their appointments to an end at the end of your administration?
Well,
they're independent boards. They're independent of the executive.
They're independent of the executive, yes, Commissioner, but at the same time, the government's policy is the one that has to be carried out. And that was our thinking at that time. Now, as we do the policies, we have since then pivoted, and we are free to do so. A man that cannot change his mind is not a man at all, the late H.L. Stout said. But we have pivoted to allow some of the appointments to stagger over, but at the same time to allow for some of them not to stagger over into a new government, because the charge of any board is to carry out the mandate of the sitting administration. If you look even at the news, if it's done differently, we'll find the processes may look a little scrubbed. But even I saw President Biden have changed some boards. Now the language would sound sophisticated, but we know what is happening there. And even in the UK, as we see, it's how it's done. It's not done in terms of this informal way. So it seems a little cleaner, but in the actuality, what it's saying is that to get fresh, innovative persons that will allow themselves to identify themselves with the core values of what you're trying to achieve in the public interest, so that it can happen much faster. You may be on a board selected by any government, and that government loses, and then the new government comes in. In my opinion, you should voluntarily resign if you do not intend to serve, to allow the policies of the new administration to be done so that it can be done in the public's interest. This is true for no matter what government is in place. I'm not speaking now of my government. This is just how I see it. Because if you are not convinced that the government that took over, if you are back in Tory and Labour got in, you have to make a decision, can I support the Labour's agenda? And if I can't support it, why stay there and frustrate the Labour's agenda for the people? So at the end of the day now, it was that kind of thinking to allow persons who can say, well, all right, although I didn't support you, I support your values, I support what you're trying to get done for the people. And that is obvious with some of the persons we have put on the board who ran against us in the elections and who didn't support us, that we knew were openly with it. And they are on some of the boards that we do have. Why? Because they have an open mind, they are progressive thinking, and they want what is best in the public interest of the people. And that's what our government was about from the onset. Some may agree or disagree, but that is our intent then and now. We're doing things slightly different now that we have matured more into government. Yes, as you get older, you should become wiser, and you should also adjust what you're doing. The Bible says you get older, you put away childish things, but you should never allow yourself not to be childlike, because the hunger is being in childlike. The hunger and the desire to get things done for the people and to keep it in the public's interest. So I hope I capture in a capsule form as best as I can, being in it in 22 years, in a capsule form, why we were looking at it in this vein. So
but a member of a statutory board has to do the functions that are in the Act.
Exactly.
And that's what the House of Assembly has assigned them to do. That's their job.
Exactly.
Uninterfered with by the executive.
Exactly. But may I add, if our intention is, and not as I don't want to use or, if any government's mandate is to bring 6G, for example, to the telecom, we have 5G, we're going to end up with 6G, we're going to have many Gs. But for a better choice, 5G. And that is placed on the TRC board. But the members do not feel that we need to get to 5G. But the government of the day needs it because, example for us, we need to get there and beyond, because we're now going into the digital economy. So for us, the modern day internet use being adequate and consistent is as good to us as our lands in the past, because through the internet, we now can generate new economies. But if the board members were there and didn't have that as a mandate before, and the time comes with a new government, whoever they may be, has that as a new mandate, and they do not intend to carry that out, that frustrates the public interest. So it is best for persons, in my humble opinion, and this is my opinion now, to when a government change, even if your time is over, to offer a resignation. if you know that you're not going to walk as seriously as you were walking before, to allow the new policies, or not all will be new, but to allow that new direction to move. And Commissioner, if you were given a terms of reference, and if you find Mr. Attorney Ruat is not going in that direction to help you with your mandate as much as you love him, you would have to, I wouldn't say sack, reconstitute the legal nomenclature of what you have. It's just the nature of what your assignment is, whether it's elected or you're technical. That's the way I see it, and I must be honest.
You divide between elected and technical. Elected being the ministers, technical being the statutory boards, as I understand you.
Well, technical also being technical and in the private sector. But because if you're in the private sector, Commissioner, and you have persons hired, or you take over a business, and the employees are there, and the old employees have decided that they're not going to conform to the new ownership. Nothing illegal about what they're doing. They just prefer what the old ownership was doing. Then you're going to stifle the business progress. You're going to stifle the economic, the financial viability of the business. So if you put that in a government capsule in terms of context, is the same thing. Not looking at whether the person is in the PVIP or PVIM with some of the parties we have, but is the person ready to make sure that they support and forward the cause of whatever policy has been brought forward.
But in your example, the telecoms example of 5G or whatever it is, and I don't know whether it's a legitimate example, but I understand that it's a hypothetical example. But in your example, the policy of the government would be, we need internet that supports a digital economy. That's
Exactly.
the policy of the government. Then isn't it for the telecoms board to determine how that's going to be done?
And it should be, but somebody have to do it.
But that wasn't your example. Your example was that it was the government's policy to introduce 5G.
Well, I don't know if sometimes how I put it, I'm not a lawyer, I'm in science. But exactly what you say is what I mean. This is the government's policy, you get it done.
But the government's policy in that example is the policy of the government,
Right.
as a legitimate policy, is to have internet which supports a digital economy. And then it may be for I don't know, the telecommunications authority to determine how that policy can be implemented.
Exactly, but in reasonable timing.
In reasonable, absolutely. I understand that you only have a mandate for a limited period and you want to get on with things. I understand that. But just to bring it back to this case, what happened here is not, I don't want to go over ground that we've been over today on, but to go over it again. But here you say that the government policy was to reinvigorate the statutory boards. Fine. But that wasn't the government's policy. The government's policy was to revoke the boards and then to reconstitute them.
No, it was to re-energize them. But one of the ways to do that, based on if you didn't have, you would have had to change the law. Can I add that Mr. Vance Lewis, to show that it was not political, and I dare to say this even in the public domain, was not a supporter of our government. He was known to support the former government, but he had the skills that is needed. And when you get the records from the House, it will be clear where I said that you were on the other side, but that's no problem. Once you come and fulfill the mandate of the people so that the economy can move forward, then you're good. You have no problem with this government. We need your skills. So we have him and many other examples of persons to show that it was not political. And we also have, which must be taken into account, we also have their track record over the 2 years now. Yes, we're looking at the constitution of how they were constituted. But at the same time, too, they do have a track record. So if the concerns that were being levied were ones that had to wait. Then 2 years later, then they should have shown their ugly face that there was cronyism, there was this, there was that, there was the other. But the point about it is that it does not exist, and the accomplishments of each board should form part of this discussion so that we can see if the informal process, although it needs tweaking, if it worked not only with our government, but even in the past governments where we have come up over the years to benefit from a lot of the decisions made by the boards.
Yes, yes. I mean, I'm not saying that the track record is irrelevant, but you have to look at the decision making at the time the decision was made. I mean, just hypothetically, if and this is a hypothetical example, it's not based on anything where I've seen evidence, but if, for example, a minister were to appoint his brother to a particular post, solely on the basis he was his brother, solely on the basis of his brother, it may be, coincidentally, that his brother is very good at doing whatever the post is, but that would still not be a decision that is proper, not a decision that is made in the public interest, because he's taken into account, in my example only, an irrelevant factor.
Well, if you put that example that way, but if his brother was the only head sergeant in the country,
no, that's a different.
Well, you see, with every example, we could shift to other one.
No, of course.
But I'm not saying that brothers being appointed.
No,
Understand me? I agree with you.
No, of course.
I don't want to say the brothers being appointed is good.
I understand that the fact that there's a relationship may not be the only factor. An overwhelming factor may be that is the only, I don't know, a surgeon in a particular field in the territory, and therefore has got to do that job because there's nobody else. I understand that. That's why I couched the example as I did. But that's, as I say, that's not to say that track record is not relevant to the issue.
Well, I thank you, Commissioner. I really understand what you're saying. The brother part, I do understand that's a little too close. And the challenge that the BVI have is that there was a very, in terms of, you were giving your terms of reference, which I do respect, and I know that you have to carry out a mandate. But if you see through at least my lens and even some of our lens, that the challenge that the BVI have is that there was a very negative narrative that was voiced in the House of Commons by the Foreign Secretary and even by the immediate past governor, that painted a bleak picture that has a potential of portraying the image of the BVI in a manner that I cannot agree. And that's why we have to make sure that the line of questioning, as you have rightfully been done to Prague, to make sure that our side of the story is told. And we say in our culture, every story has three sides: your side, my side, and the truth. And I believe in you, Commissioner, that when it is finished, that we will have the truth through a just outcome. And I thank you for how you have been operating it.
Thank you, Premier. And thank you for your time. And thank you for agreeing to come back on Thursday. That's much appreciated.
For sure. We'll be right here.
Anything else, Mr. Raptor?
No, say to Commissioner, just to join in with your thanks to the Premier for giving the Commission his time today.
Could I just deal with three things very shortly with Ms. Peaty?
Commissioner, before I leave, one thing, yes. I'd like to be clear. When I return is on Thursday, and what all sections we are dealing with on that time?
The remaining parts of the warning letter.
Okay, so that would be where all
Port Authority,
and
climate change,
transport.
Okay, Port Authority and climate change.
And we will. You've made 2 points about the Airports Act.
Yes, you will look for those for sure.
And also the TRC, and we'll double check those for you. Then.
I know that you will. That's why I mentioned it.
Thank you. Very short.
Yes.
Very short.
If I may, Commissioner, Thursday we set Julian Fraser for 10. Do we adjust that time?
Thursday, Julian Fraser at 10, Premier at 3.
Yes.
At 3? Thank you very much.
Sorry, Mr. Rowe, yes, 3 o'clock on Thursday for the Premier. Ms. Peaty, very short points. Firstly, thank you for dealing with the statute declarations as quickly as you did. Secondly, and I apologise if this information is in Dr. O'Neill Morton's affidavit. I don't think it is. But could I have a simple list of transfers of statutory boards into the Premier's office and the Ministry of Finance, if there are any? But I think most of them came into the Premier's office after the Premier's administration started in February. And thirdly, Sir Geoffrey referred to submissions. Firstly, he, the IRU, the AG, will want to wait, obviously, until the end of the Premier's evidence to make those. But I'm minded to allow those submissions to be made. They're to be submissions and not evidence. I just do not want to see evidence, and I certainly don't want to see further documents produced at this stage if we can possibly help it. And they will be limited to a number of pages. Let's see how we get on with the evidence before I give a limit, but it'll be 5 or 10 pages. And what I'll do, Ms. Petey, is give some thought as to, and I think, if I can put it in this inelegant way, I think Sir Geoffrey wants to go freestyle. I think he wants to make submissions on, or the IU wants to make submissions on whatever he wants to make submissions on. But I'll also give some thought as to whether there are any particular issues upon which the AG may be able to assist. And we can deal with that perhaps at the end of the Premier's evidence on Thursday.
Okay, grateful, Commissioner. Thank you.
Good. Thank you very much. Thank you, Premier.
Thank you. Thank you, my good friend.